Good morning, ladies and gentlemen. My name is Mark Ballots. I'm the Deputy Secretary of State for Elections. I just want to let you know we got about 7 more minutes or so until we kick this workshop off this morning. I appreciate you joining us today, though. But I'm going to put myself on mute and shut off my video, and then right at 8, I'll turn it back on, and we'll get ready to kick this off. But thanks again for joining us. All right, good morning, ladies and gentlemen. See a couple, 2-3 people still joining, but we're going to go ahead and kick it off real quick. The first thing I'm going to do, though, is copy and paste into the chat this morning. This is the agenda for today. Oops, that one is not. 1 second. One moment. Let me copy it in there real fast. That way you guys all have the same document. We're working off the same page. Oh, wait, maybe it is. Yes, it is. I'm sorry. All right, so that's the document. It's 134 pages. As we go through these regulations today, I'm going to cite the page number on that document. So if you do have a different version of it, or maybe, again, I know some people were copying and pasting different portions of the regulations. I'm going to reference that one just so that we're all on the same page and you can follow along at home. Okay, good morning. I'm going to call this workshop to order at 8:01 a.m. For the record, I am Mark Voloshin, Deputy Secretary of State for Elections, and I'll be conducting this regulations workshop today. Before we begin, I want to clarify a few things. Our discussion today during this adoption hearing will be focused on the proposed regulations listed in the agenda. We should not discuss changing statutes, which are, of course, created by the legislature. This regulatory process will not alter any existing laws, nor can these regulations conflict with existing statutes. Following the completion of the workshop today, the next step is an adoption hearing on February 22nd at 8 a.m. February 22nd at 8 a.m. I'm going to copy and paste the agenda and notice for that one into the chat as well right now. Okay. Following that adoption hearing on February 22nd, the final step in this process is actually the Legislative Commission, a meeting that will go on February 28th at 1 p.m. That's Legislative Commission. I'm going to copy the link. I just hit send on that one. That link takes you to the Legislative Commission page. So that way you're able to see, again, that's when the notice about the meeting comes out, the Zoom link, physical location if they have one, that sort of thing. That will all be at that link there. Just perfect. Why the links in that document are working, I'm not certain. I guess they may have changed, but if you just scroll down in that document, it actually has the regulations themselves. So the hyperlinks, I guess, for whatever reason, they linked back to some, I think it was a legislative page that is, I guess, since been modified. That's not something in my control, unfortunately. But again, if you just scroll down on that 134-page document, all the proposed text is in there. Regarding the workshop today, and as a reminder, there are 3 ways to indicate you wish to make a public comment. You can click on the raise hand icon in Zoom, which is down. If you don't see it, it'll be down in on the bar at the bottom. You'll see a little button that says more with 3 dots above it. If you click on that one, you'll see the chat. So you can either put I'm sorry here, more or reactions. I'm sorry, reactions has the raise hand. You can click raise hand in the reactions button, physically raise your hand on camera, or state in the chat that you'd like to make a comment, and the chat is located in the more button. If there are general questions about elections procedures, I'll be able to discuss them as long as they relate to the proposed regulation that we are discussing. If there are questions that extend beyond the regulations on the agenda, I would be more than happy to set up a separate meeting at another time. To do so, please contact me at nblect@sos.nb.gov. And I will put that email address as well into the chat. That is something of note. I've been fairly loose in my adherence to the agendas. Over the last few workshops and adoption hearings, I've made a point to provide additional information that maybe skirted the boundaries. I have been counseled on that and will be a little more strict today appropriately. But please understand, again, more than willing to discuss matters at any time with you, but we'll have to do it separately again, and we can set up a meeting by contacting me at the nblect@sos.nb.gov. Finally, participants in the workshop are reminded to treat one another with dignity and respect. This includes the use of the chat, which is primarily intended to enable participants to indicate they wish to make a public comment. Okay, this is the public workshop for the Secretary of State Elections Division, proposed regulations with the LCB file numbers. One second. Oh, there we are. With the LCB file numbers R087-21P, R088-21P, R089-21P, R090-21P, R091-21P, R092-21P, R093-21P, R094-21P, R095-21P, R096-21P, R097-21P, and R098-21P. The text of all proposed regulations has been provided. The notice of workshop to solicit comments on proposed regulation was noticed at all required locations on January 19th of 2022. So since the first workshop, the Secretary of State has continued to receive written public comment from organizations and individuals. We will continue to review and consider it in preparation for the adoption hearing on February 22nd. So again, the discussion today is primarily focused on receiving public comment on these regulations. We have already conducted one workshop beforehand. We have all of that public comment still recorded, as well as the written comment we have received since. So again, today, if possible, if there's something to enhance or augment the written or verbal feedback we've already received, then by all means, if you have not had a chance to provide public comment before on these agenda items, again, more than welcome to do so. But just please be mindful that we do have already in the record the written and verbal comments received at our previous workshops and received in the Secretary of State's election division. And the most recent came in 13 minutes ago. So again, that information continues to be received, will be reviewed, considered, and discussed for possible inclusion into the text of these regulations. That will be discussed on January 22nd, again, during the adoption hearing, very similar to the two adoption hearings we had yesterday and the day before, where we will go into detail on what changes are ultimately adopted as part of that process. And then again, even the adoption hearing is not the final part of the process. Just to clarify, again, that the Legislative Commission on February 28th at 1 p.m. That's also an opportunity to provide additional public comment and written feedback. Except that time, the focus will not be the Office of the Secretary of State, again, but instead your legislators on the Legislative Commission. Okay, so moving on to the agenda, public comment on matters other than the previously listed LCB file numbers. Comments will be limited to 2 minutes per person. Is anyone interested in providing public comment about a matter not on the agenda? If so, please identify yourself. And this is, again, throughout the workshop today. When I do call on you, please state your name for the record so that way we can make sure that we're taking notes appropriately. But if anybody's interested in making a public comment on matters not on the agenda, excuse me, please go ahead and indicate so in Zoom now. Mr. Beatles, do you have a comment?
Yes, sir. Good morning. Yes, good morning, everybody. Robert Beatles, Precinct Captain 5030. So again, here we are again at one of these workshops. Again, I feel that all this stuff is unnecessary. We actually created a petition. Now it's a resolution that creates a free and fair election in the great state of Nevada. All this here just makes it more kind of convoluted, I guess, by design. If you really want, excuse me, a free and fair election, just adopt our resolution. Creating legislation outside of legislature is not legal. You have that little disclaimer you read off to all of us. I heard you, but again, I've seen the changes in these documents. I've seen the blue ink. Those are your guys' changes. That's what you're asking this committee outside of legislation to basically you call adopt, but it's enact. So again, the attorneys and I'm sure the judges will prove that all this stuff here is just unconstitutional. It's just, again, waste of all of our time and trying to just muddy up our election system even more so than it already is. Now, if you can't, again, with these machines, And can you state for the record for all of us here who Chris is? Chris Washoe? Is that your dad there for ES&S? Who is that gentleman?
Mr. Beatles, are you done with your 2
No,
minutes?
no, it's a question directed to you. Can you explain to us who Chris is?
Oh, absolutely. Well, I'll get to that here in a second. Nothing to
Oh,
hide.
that's just
My
simple
genealogy
question.
is
What's the
kinda
largest
exciting.
voting machine in the country? So that's why I was wondering,
Certainly.
is that your dad?
No.
Uncle?
Yeah.
Okay, gotcha. So anyways, as we can't audit the source code with these machines that we have here in Nevada, again, just goes to show you that we have a fraudulent election system. Simply telling us to trust you and that we're the conspiracy theorists is kind of, ridiculous here. We have proof that the voting machines are using an algorithm to disenfranchise every voter in the great state of Nevada to 0.63% of a vote. All this stuff can be replicated a million times over. If you just have a simple a 6th grade math teacher, he can run the algorithm and see exactly what we're talking about and how it's true. But again, just telling us that we're wrong without any proof when we have it, that's the real conspiracy theory here. So again, I believe that these workshops are just scams, and we all know it. You guys are using fancy words and hiding behind fancy suits to just, further corrupt our election system. We're not stupid. We know what's going on. And then again, to everybody that's, playing a part of this, I mean, if they really like China so much, they should move there. We don't want communism. We want our republic to stand, and we don't want all these changes to our election system. We want a free and fair election system. So adopt our petition, which is now a resolution, and we can have free and fair elections again in Nevada.
Thank you for your comments, Mr. Beatles. We'll take them into consideration. And just to clarify, there was one question in the chat. I don't believe he's referring to a ballot initiative. Again, of course, our petition process is identified in the state constitution and further defined in statute and regulation. I believe he's referring to something else. I haven't seen yet a notice of intent or any of the other initiative type documentation come across my desk yet. But if so, we will post it on the Secretary of State's website as soon as possible. Mr. Ott, do you want to address the question in regards to the legalities of the proceedings today?
Yeah, happy to do so. Greg Ott, Deputy Attorney General, signed to assist the Secretary of State in these adoption proceedings. As a brief overview, some of you, for those of you who heard this at the previous workshops, I apologize for being repetitive, but all power to adopt regulations flows from the state legislature. In chapters 294 and 293B of NRS, they delegate specific regulatory power to the Secretary of State. The Secretary of State is only allowed to adopt regulations related to that power specifically delegated from the state legislature. The rules regarding adoption, modification, and amendment are all set forth in chapter 233B of the Nevada Revised Statutes. That's also adopted by the legislature. That's called the Administrative Procedure Act, which talks about what public agencies can and can't do when they're making these rules. The word adopt is clearly defined in there to encompass everything that's going on in these workshops and these processes. Additionally, the text of the regulations that you see is all drafted by the lawyers for the legislature, LCB, also known as the Legislative Counsel Bureau. They are the masters of this process. So the Secretary of State's office says, hey, we want to do regulations on A, B, and C. They send the request to the lawyers for the legislature. The legislature then either says, yes, you can, no, you can't, and they will send back a draft to the administrative agency. That agency will then post those. That's the document that Mark has posted in the 134 pages that he's referenced. And sometimes the LCB lawyers will say, no, actually, you can't make regulations. The legislature hasn't delegated you that authority, or you're coloring outside the lines. You're trying to do too much. So one of the things that is difficult for me is, even though I'm the attorney advising the Secretary of State in these proceedings and making sure they observe the open meeting law, I don't write the text. I don't actually, my word is not the final word on whether they are coloring within the lines. This is a legislative process driven by legislative lawyers. So for those of you who have concerns about the process, please take a look at NRS 233B. It's very clear. And take a look at NRS 293B and 294 for the delegation to the Secretary of State. But I hope that you have some comfort in those citations. And with that, I will hopefully go away for a little while.
Thank you, Mr. Ott. Appreciate your input. And again, just to clarify even further on what Mr. Ott said, we drafted initially again, in our discussions with the clerks and in reviewing over the last year, every one of our regulations. We started with, again, chapter 293, went all the way to chapter 306, which again, some of you may not realize, but ultimately there's multiple chapters of Title 24, the state laws relating to elections. Excuse me. And then we provided those drafts over to LCD to help clean them up and continue that discussion. Perfect. But now that we've discussed the process a little bit, and again, I don't see, is there anybody else interested in making public comment on an item not on this agenda? Okay, seeing no more public comment, I will close the public comments on items not on the agenda, and we'll move on to the regulations. It is noted for the record, the regulations will be addressed one at a time in numerical order. Public comment will be taken in the same order, and public comment on a particular regulation will be closed before moving on to the next regulation. Before public comment is opened on each regulation, I will read into the record a summary of the proposed changes. And we will start with, okay, at this time I'll open the workshop regarding proposed amendment R087-21P. If you were following along on the text, I am down on page 8 of 134, page 8. Existing law provides that in order for a mail ballot to be counted in any election, the mail ballot must 1, be delivered by hand before the time set for the closing of the polls, or 2, mailed to the county or city clerk as applicable. If a mail ballot is mailed to the county or city clerk, the mail ballot must 1, be postmarked on or before the day of the election, and 2, received by the clerk not later than 5 p.m. on the 4th day following the election. Existing law provides that if a county or city clerk determines when checking the signature used for the mail ballot that 1, the voter failed to affix his or her signature or failed to affix it in the manner required by law, or 2, there is a reasonable question of fact as to whether the signature matches the signature of the voter, the clerk must contact the voter and advise the voter of the procedures to provide a signature or confirmation that the signature used belongs to the voter as applicable. For the mail ballot to be counted, the voter must provide a signature or confirmation as applicable not later than 5 p.m. on the 6th day following the election. This regulation provides that if any such deadline falls on a legal holiday, the deadline is extended until 5 p.m. on the next working day. At this time, I will open up public comment specifically on proposed regulation R087-21P. If there's anyone who wishes to speak and provide feedback regarding this proposed regulation, please go ahead and indicate so in Zoom now. Mr. Moore, good morning.
Good morning again, Mr. Ballots. This is my very first workshop, as yesterday was my very first participation in anything. So if I'm a little bit out of line, feel free to correct me. This second part, well, of course, I'm against all of this. I don't believe in machines at all, and I don't believe in mail-in. But what really disturbs me here is this number 2, where we give even another chance for mail-in ballots and more doors open to fraud. As I mentioned yesterday, I've done it for 30 years. I know the responsibility of a person that is using the opportunity for mail-in ballot when you're living overseas. But then it is our responsibility, whether it's military or whether overseas citizens, it is our responsibility to make sure we do it right, do it on time. And if we don't do it right and don't do it on time, sorry, end of story. We should strike this completely. That's my comment.
Thank you, Mr. Moore. Appreciate your comment. We'll take it into consideration. Ms. White, good morning.
Good morning. I'm just wondering, the actual law that the legislature passed, is that what is indicated in black? Because I would like to compare. I guess I'm not understanding. The black that we see in the document, the 134-page document, those are all regulations, existing regulations. So where do I access the law so I can compare that these regulations are reflecting what was intended in the law? Am I clear? Do I?
Yes, ma'am. So the black text is part of NAC, the Nevada Administrative Codes, Chapter 293. I just copied the link to that into the chat. Those regulations cite, and you'll notice, for example, under, I will pick a random one about sample ballots, just for a quick hip pocket class. If you look at that NAC 293-120 at the very top, it has in bold the name of the regulation, and then in parentheses, the statutes that it cites, and it reference the requirement for, for a regulation, or refer to the authority allowing that, the establishment of that regulation. So in this case, it's got 293-124, 293-247, and then 293-565. And those are the, so again, regulations are really guidelines or clarifications about the statutes, again, which is why they can't ever conflict or cancel a statute, because the statute is the guiding document.
Right, but the administrative codes were also written by legislative staff. I would just like to see what the language is of the actual AB 321 or AB 4, whatever it is, so that I can compare that these regulations are actually in line with what the law that the legislature passed.
Yes, ma'am, and I appreciate that, truly. I just copied the link into Nellis. Nellis is the website portal that the legislature uses for the drafting and publishing of bills from various legislative sessions. The link I just sent to you is for the 81st session. And in the top left, if you go to legislation and then click all bills and resolutions, you have the ability to search. So for example, if you go down and search for 321, you'll see the link to Assembly Bill 321, which looks suspiciously like that link that I just put into the chat. And that provides the text as the document was amended through the legislative session, along with the text that was finally enacted. You'll see the fiscal notes. They have the meetings. You can actually go back and watch the meetings and hear testimony about the bill, hearing the comments of people that were for or against it. You can see the votes as well of which legislators were for or against it, along with a number of other exhibits. But thank you so much for asking about that, because I agree, like, to do your own research. These are the root legal documents in the framework that you'll need for that. So I appreciate that.
Okay, thank you.
Yes, ma'am. Ms. Martinez, good morning.
Good morning, Mark. For the record, Cindy Martinez, Vice Chair of the Washoe County Republican Party. Do you know if there were any documented circumstances in the state of Nevada where the dates of mailing or receipt were falsified, as we saw in other jurisdictions across the country? Because once again, here we have a law and a corresponding code that would, in good faith, whether you agree with it or not, is intended to administer the intent, the legislative intent of the law. It still comes back to the subjective handling of human beings that are in this process. Every time a human being is touching my vote, from the time that it leaves my hand to when it's actually tabulated, is a point of vulnerability and insecurity in our never to be humble opinion. So my question is, do you have any documented circumstances, any knowledge, even if it's fleetingly anecdotal, of mishandling of ballots and falsification of mailing and receipt at the U.S. Postal Service? Thank you.
Yes, ma'am. No, nothing comes to mind in regards to, and I certainly would remember an instance from the 2020 general election. Please keep in mind too that, again, I was appointed as the deputy for elections in October of 2020. So before that, again, there might have been something that I hadn't heard, but more specifically, I'm only going to speak to the 2020 general election because that's really where my focus has been over the past 15 months or so. And in regards to malfeasance at a postal office, I have not heard of that. In regards to mishandling of ballots, deliberate or accidental, I have not heard of that either, either from a postal worker or any staff member that I heard of from any of the clerks. In fact, if you have heard of something, please let me know, because I absolutely will investigate that and look into it further. But in regards to your concerns about the subjective handling or the spectrum of human involvement in handling, I understand your concerns and have made note of them. Ms. Saunders, good morning, please.
Good morning. Christine Saunders, Policy Director with the Progressive Leadership Alliance of Nevada. Vote by mail has been proven to be safe and effective in many other states, some who have utilized it for decades, like Oregon. We believe it is important for voters to have sufficient time to cure their mail ballots with signature issues and recommend that the regulation clarify how the attempts to contact the voter will be made, and that we utilize multiple forms of communication, whether that be mail, phone, text, email, or door knocking. Thank you.
Thank you, Ms. Saunders. We'll take it into consideration. At this time, oh, Ms. White, yes, please.
Thank you. Going with the previous speaker's comments, are those phone contacts to cure the ballot done in a bipartisan manner, or is one individual carrying it out, completing the action?
Do you mean, are there multiple people on the phone making the phone call? Is that, or do you mean, are there multiple people of different party affiliations making the call? I guess.
Actually, I mean, on the phone call where they try to attempt to reach the voter, they reach them, and there's just one person talking to them and getting the answers.
So there's a number of ways that signature curing occurs by phone. In some cases, individuals will call to let them know to come into the office, and then the individual will come into the office to cure their ballot. I don't think I can speak to all 17 counties as to the exact procedures, though, for each instance.
Well, wouldn't it be a good idea to include regulations that describe the process where the curing is done, or is that in regulation that specifies exactly how it's supposed to be done?
There are statutes and regulations to talk about the signature curing process, ma'am, and I will take down your recommendation to maybe enhance or further clarify that to standardize.
But to standardize, as far as, I don't trust one person, you know, you got to be able to observe or have multiple parties doing the action. That's the only way you're going to have transparency. So as the curing process is done, it needs to be done with witnesses or whatever. It can't be a single person, in my opinion. Thank you.
Yes, ma'am. Thank you for your comments. Mr. Parks, good morning.
Good morning, Mark. For the record, Bruce Parks, Chairman, Washoe County Republican Party. I just wanted to pile on with Valerie White's comments about the curing process. The curing process is what led to a lot of the voter fraud that occurred across the country. The people that were curing ballots were not actually curing anything. And in some instances, we have video proof of that fact. The entire ballot curing procedures are not sufficient to preclude a person with malintent from negating my vote. Thank you.
Yes, sir. Thank you for your comments. At this time, is there anybody else interested in making a public comment regarding proposed regulation R087-21P? Okay, thank you. At this time, I will close public comment relating to proposed regulation R087-21P, and we will move to proposed regulation R088-21P. For those following along, I am now on page 12 of the document. Existing law authorizes, under certain circumstances, a person to cast a provisional ballot if the person registers to vote in person or updates his or her voter registration information as applicable at a polling place. Existing law further authorizes a person to cast a provisional ballot if the person completes a written affirmation and 1, declares that he or she is registered to vote and is eligible to vote in the election in that jurisdiction, but his or her name does not appear in the voter registration list. 2, has registered to vote by mail or computer, has not voted in an election for federal office in the state, and fails to provide identification to an election board officer at the polling place. Or 3, declares that he or she is entitled to vote after the polling place would close as a result of certain court orders. Existing regulations set forth various provisions related to the latter type of provisional ballot. Sections 1, 6, and 7 of this regulation define the term provisional ballot for purposes of these sections to clarify that the provisions apply only to the latter type of provisional ballot. Existing regulations require the Secretary of State to send each county clerk a written notice designating the offices for which candidates are to be nominated at a primary election, and requires each county clerk to publish the notice in a newspaper in his or her county within 10 days of receipt. Section 2 of this regulation requires the Secretary of State to also, 1, send an electronic notice to each county clerk, and 2, post a copy of the notice on the website of the Secretary of State. Section 2 further requires the county clerk to publish this notice on the internet website of the county clerk, and provide that if the county clerk is unable to publish the notice in a newspaper within 10 days due to the publishing deadlines of the newspaper, the county clerk must publish the notice as soon as practicable. Existing regulations set forth the years in which the seats of the offices of Justice of the Supreme Court are to be elected. Section 3 of this regulation updates these years. Sections 4, 5, 14, and 15 of this regulation eliminate obsolete references to an acceptance of candidacy, as that term is no longer used in the Nevada revised statutes. Existing regulations require the county clerk and city clerk to mail at least 5 sample ballots and to provide an electronic sample ballot to the Secretary of State. Sections 5 and 16 of this regulation instead require the county clerk and clerks to provide only an electronic sample ballot to the Secretary of State. To be clear, they are still providing this sample ballot example for our review, but just simply not requiring, they're not required to send 5 sample ballots. That in decades past, those were the documents that were reviewed. Now we're able to review the digital versions that are sent to us in high def, so that again, the same effect is achieved. Existing regulations require each county clerk to submit to the Secretary of State a voting history for each voter in the county who casts a ballot in an election not later than 45 days after each primary or general election. Section 8 of this regulation instead requires the county clerk to send the voting history not later than 45 days after every election. Existing regulations require certain election complaints to be filed in the office of the Secretary of State in Carson City. Section 9 of this regulation removes the requirement that the complaint be filed in Carson City. Sections 9 to 13 of this regulation update existing citations to the Federal Help America Vote Act of 2002, Public Law 107-252, 52 U.S. Code 21081 to 21102 inclusive. That being said, at this time, I will open public comment regarding proposed draft regulation R088-21. If you are interested in making public comment on proposed regulation R088-21, please go ahead and indicate so in the Zoom now. Mr. Parks, please.
Again, thank you, Mark. Bruce Parks, Chairman, Washoe County Republican Party. As I understand this, if I'm not reading it correctly, please straighten me out here, but it looks to me like if person has a problem with their ballot here, there's an additional 10 days after the election for that to be taken care of. That would extend the length of time that it takes for us to get an accurate count for the election. Am I misunderstanding that, Mark?
Sorry, I don't see the text. The bottom line, even with the provisionals, is they're under the same timelines that the rest of the ballots are. So we have 4 days after election day to receive mail ballots, 2 additional days to cure, and so it's a 6-day curing process. And then the county county commissioners are required to certify their county elections no later on or before the 10th day after the election. So these provisional ballots are adjudicated before that county commissioner requirement. So again, this does not influence or affect the timelines in an official means. This is again part of the process, and we talked a little bit about the bottom-up nature of our system. That because of that, we have to wait until even the signatures are cured on that 6th day before we can compare provisionals. But that is, as you can imagine, a top priority for day 7 following the election. But otherwise, there are no impacts to the overall timelines as it relates to either the county commissioners or the Supreme Court canvass.
Thank you for straightening me out on that, but it's still, I don't know how it worked in some of the other counties across the state, but I know here in Washoe County, provisional ballots were cast and counted the same way a regular ballot was cast and counted. And part of the problem that created that situation was the same day registration. Folks registered on the same day as the election, cast a ballot. The ballot was supposed to be treated as a provisional ballot, but was in fact not treated as a provisional ballot. It was treated as a regular ballot and was cast or was counted just the same way my ballot was counted. Is there a plan to preclude that possibility here from taking place again? I don't see where this regulation would prevent that. Thank you.
Yes, sir. I appreciate your comments. We'll certainly look into that. Again, just like you said, those provisionals are not to be counted the same day because of the requirement to wait for everyone else's provisionals across the state to be gathered following the signature curing timeline. But yes, sir, I'll take that into consideration. We'll look further into that. But thank you for your comments. Ms. Thomas, good morning.
Good morning. I was just going to ask, were you able to, is there any way to ensure that the provisional ballots are processed on paper and not electronically on the voting kiosks?
Ma'am, that's something that we're still looking into to ensure that one way or the other, the provisional ballots are not included again within the same count as everybody else. Because you're right, there needs to be a way, and I believe we talked about this before. And to clarify for the record, Ms. Thomas's concern, and please correct me if I'm wrong here, but if they were done on a machine, and if that machine was just no different than any other machine, or even still, if 4 people cast provisional ballots on a machine, and then one of those individuals is not identified later on as being an eligible voter, it would be understandably, at least the perception is, unless I'm missing something here, difficult to not cast their ballot. So yes, ma'am, certainly something that we're looking into to make sure is in place before the coming election cycle.
Well, the challenge comes into play is linking that voter to their specific ballot.
Exactly. Yes, ma'am.
Yeah, so you have no way of doing that when they're on the machines, as far as I know right now. But is there something, that text that we need to put into this regulation stipulating that those definitely need to be held separately and that they need to be on paper so they can be still linked to the voter in an envelope?
I understand, ma'am. Yeah,
Okay.
I'll certainly add that in and we'll consider it. Thank you.
Thank you.
Mr. Moore, please.
Thank you. How many provisional ballots were actually not cast, but actually performed in 2020 general election for the state of Nevada?
One moment, sir. Let me check real quick, see if I have that number handy. So I'll be able to, I'm making a note to get back to you on that. I just don't have it handy in the interest of me keeping the meeting moving along. I'll get that information. The number of provisionals that were cast, I'll be able to get.
Yeah, if you can give the 2 numbers, the total, that were actually attempted to be counted and how many were actually eligible. And are the provisional ballots physically different in form or in color or in any other easily visible difference between the regular ballots?
I know that again, at least for the clerks that I talked to, and again, I'll clarify in regards to the questions Ms. Thomas had earlier, they are typically kept separate and far off to the side, not even close to being in close proximity to the rest of the ballots, in part because again, they don't want there to be any question or accident about casting a provisional ballot before that individual, 1, has been confirmed as being an eligible voter, and 2, we've had the opportunity across the state to compare provisionals to make sure no one's trying to pull a fast one and cast a provisional ballot in multiple counties.
I would just put down, if you don't mind noting it, I think it needs to be extremely different visually, because as we have seen in other states, ballots seem to float from one section to another, and it should be a red flag. It should almost be like a hunter's orange or lime green and then when someone sees it in the pile, it should be easily observed visually.
I understand. Thank you for your comments, sir. I will certainly take it into consideration.
Thank you.
Ms. White, please.
Thank you. This is for section 4.1, and it's not really a modification or edit, but I just want clarification. It's saying that a candidate may change the manner in which his or her name will appear on the ballot. Does this include nicknames? We recently kind of had an issue with that in the last election, I think. They can't, it has to be their legal name. It can't be a nickname that they can change it to. Is that correct?
Ms. White, did I provide the statutes for you yesterday that talked about the nicknames and all that?
I don't think so.
Uh,
I don't remember asking a question like that.
One moment, please. There were some questions that came up in regards to names on ballots, and there's provisions in NRS 293, specifically NRS 293.265 and I'm sorry, 256 and 2565. I'll copy both of those links into the chat. But there's a specific statute that relates to the use of names or nicknames on the ballot.
Thank you.
You're welcome. At this time, is there anybody else interested in making public comment relating to proposed regulation R088-21P? Mr. Benton, good morning. Mr. Benton, do you have a comment to make? I'm sorry, I can't hear you, sir. You're still on mute.
Okay, sorry. I'm having problems, but I just wanted to point out that I think that as was brought up, we should have separate ballots with a different color, or that we should have a separate machine so that it would keep a difference between the regular machines and the provisional ballots. Thank you.
Thank you, Mr. Benton. Appreciate your comments. We'll take it into consideration. Now, at this time, is there anybody else interested in providing public comment on proposed regulation R088-21P? I do not see any public comment. Okay, so this time I will close public comment on proposed regulation R088-21P, and I will open the workshop on proposed regulation R089-21P. For those following along in the text, we are now on page 27, page 27. Assembly Bill number 321 of the 2021 legislative session repealed existing provisions of law governing voting by absent ballot. Consistent with the changes made by AB 321, Section 9 of this regulation repeals obsolete regulations relating to voting by absent ballot. Sections 1 to 8 of this regulation eliminate obsolete language related to voting by absent ballot. At this time, I'll open public comment on proposed regulation R089-21P. If anybody is interested in making public comment on proposed regulation R089-21P, please go ahead and indicate so in Zoom now. Mr. Benton, your hand is up. Do you have public comment on this? Oh, yes, sir. Is there anybody interested? Mr. Moore, please.
Can you just give us, please, a little quick summary of what the intent of this regulation is? I'm confused.
Yes, sir. Certainly. So simply removing obsolete language based on, so again, a lot of these regulations, when we do our regulatory review, we start, like I said, we cover all of the elections related regulations. One of the very first things that we did was to go through them with a fine-tooth comb, considering the laws that were passed during the legislative session. I guess that wasn't, we actually started with updates. I'm sorry, because we started this in January before the legislative session of 21 even started. But when the legislative session ended, we went back through and with a fine tooth comb, we thought, all right, of all the bills that were passed, right? And we're talking Assembly Bill 284, 121, 126, 166, 321, 390, 422, 432, Assembly Bill, no, Senate Bill 292. There we go. That was the other one. So we considered all of those elections related bills that were passed and then went back to the statutes that they related to, and then looked at the regulations relating to those, and then made sure that if there was outdated language, that was included in the text and updated. So this is really,
when I read through this, I see red crossed out and so forth. Is that indicating what the language was that was removed, or that's just a correction of the process to remove language that was obsolete?
Yes, sir. Our proposed regulation, which is an amended version of the old one by removing obsolete text. Yes, sir. And in that red font with the red strike, that's the same thing you'll notice during the legislative session as bills are amended, and initially they'll be proposed and it's all in black, and then the next version will come out and there'll be some red, but then some blue as other things get added in. There's
It's
actually
like a Microsoft Word tracking.
exactly. And in fact, it can get, there's I think a green and a purple time.
Yeah, no, I understand.
Yes, sir.
Is it possible by looking at this that I see an example of an obsolete language that was removed?
Absolutely, yes, sir. So if you go down onto page 30 of the document,
Yes.
just the idea of the term absent ballot is no longer applicable unless you're referring to a UOCAVA, the Uniformed and Overseas Citizen Absentee Voting Act.
Which letter are we talking about? G?
In G, yes, sir. How in absent, or they crossed out absent. Further down in the page under in section 4, subsection 2, how it says if a precinct has fewer than 10 returns of, and then the word absent is crossed out. Yes, sir, and just replaced with mail, because that was, and again, those are all parts of the language gets updated based on the language in the bills that you'll see, and that one relates to Assembly Bill 321.
Okay, and the reason why, just for the record, the reason why I'm asking that, it seems to be my opinion that nefarious uses of this process could exist. And I don't say that for you or for your office or for Nevada or anyone specifically, but somebody could say, hey, you know what, let's just say that this is an obsolete term, change the term that is either more broad or more stringent, without us as citizens who scan over these documents to really know that we have just been, I won't use the word, but anyhow, that's my concern. And of course, I don't have time to do this now. I wish I would have, been more involved in the past. But is there any intent of your office to change the meaning of any of these things, or it was just to put synonyms in there?
Yes, sir. Just to clarify the text, and in fact, I will let you know that if there are amended regulations that change definitions, those go through the same process. And there have been definitions that were discussed with the lawyers at LCB and with Mr. Ott that were deemed to be incompatible with existing statutes. So we can't define something in regulation that conflicts with a statute to try to. And that's not just this office, I'm not suggesting we would, but if there's the statutes and the definitions in the revised statutes trump everything, and we cannot clarify that. We cannot be inconsistent with those. We can clarify and risk limiting audits, for example, you may remember yesterday, we added definitions to clarify what we're talking about and to further define those processes. Those are something that conceivably could be put into law through the BDR process. But as it was proposed as a regulation, again, they didn't conflict with any definitions of risk limiting audits. They simply enhance understanding and transparency. But yes, sir, I understand your concerns. And for what it's worth, this is the part where, again, if you felt that one of the definitions was inconsistent or incompatible, then certainly we'd be able to take that feedback and possibly consider clarifying it.
Okay, thank you.
Yes, sir. Ms. Ramos, good morning.
Hi, good morning, Mark. This is Mary Janet for the record with All Voting is Local Action Fund. And our recommendation for this body is to help clarify the process in regards to how county clerks will be handling rejected mail ballots. And this includes the process in notifying the voter that their mail has been rejected and giving them the opportunity to cast a ballot if they have been involved in a situation that their ballot has been rejected or tampered with. Thank you.
Thank you, ma'am. We'll take that into consideration. I appreciate your comments. At this time, are there any other individuals interested in making public comment relating to proposed regulation R089-21P? Okay, this time I will close public comment then on proposed regulation R089-21P, and I will open I will open the workshop on proposed regulation R090-21P. For those of you following along, we are now on page 51. Page 51. Existing law requires the county and city clerks to send to each active registered voter and to each person who registers to vote or updates his or her voter registration not later than 14 days before an election, a mail ballot for all elections. Existing regulations: 1, require each county clerk or city clerk to provide with each absent ballot certain instructions for correcting a mistake on the absent ballot, and 2, prohibit a county or city clerk from duplicating an absent ballot unless there is no ambiguity as to the intent or the voter. Section 2 of this regulation set forth similar requirements for mail ballots. Existing regulations establish certain procedures for processing an absent ballot, including 1, requiring the county or city clerk to record the receipt of the absent ballot and check the signature on the return envelope, and 2, the placement of any rejected absent ballots in a separate envelope and the notation of the reason for the rejection. Sections 3 and 11 of this regulation: 1, set forth similar requirements for mail ballots, and 2, require the county clerk and city clerk to keep accurate records of the chain of custody for all mail ballots. Existing regulations establish certain requirements for an absent mail ballot central counting board, including requiring the board to sort out and count absent ballots by precinct. Existing regulations further require, with certain exceptions, the county clerk or city clerk to allow members of the public to observe the handling of absent ballots. Sections 4 and 12 of this regulation establish similar provisions for mail ballots. Existing regulations require each county clerk and city clerk to submit a plan to the Secretary of State setting forth the procedures that the clerk will use for the disposition of absent ballots in case of emergency. Sections 5 of this regulation establishes similar requirements for mail ballots. Section 6 of this regulation defines the term mail ballots. Sections 7 and 9, 13 and 14 of this regulation eliminate obsolete references to the term absent ballot and various provisions that will instead apply to mail ballots. At this time, if you are interested in providing public comment regarding proposed regulation R090-21P, please go ahead and indicate so in Zoom now. Ms. White, please.
Thank you. I don't know if it's early in the morning or what, but I've seen some language in here, and specifically you can go to 2.2, and it's that sentence there is confusing. A county or city clerk shall not duplicate any mail ballot the voter has marked to indicate a correction or on which the voter has used correction tape or fluid, unless the clerk determines that no ambiguity exists as to the intent of the voter. So it's kind of saying, if it's really clear, they shouldn't create another ballot. That no ambiguity looks like there's 2 negatives in that sentence, which makes it confusing. Shall not duplicate and no ambiguity. Do you see what I'm saying? If you read it backwards, it makes it a little more clear, but it is confusing. And it's in the next regulation as well. And I didn't even get any farther than that, but. So if no, is it just too early for me to think right?
No, ma'am, I understand your concerns in regards to the language. I'll make a comment about that and see if we can't consider a different text.
Thank you.
Yes, ma'am. Ms. Guerrero, please. Morning.
Good morning, Mr. Roshan. For the record, my name is Matilda Guerrero. I'm the Democracy Manager at Silver State Voices here on behalf of the Let Nevadans Vote Coalition. We are in full support of this regulation because it cleans up some language and helps to provide more clarity in our administrative codes by referring to mail ballots as mail ballots and not as absentee ballots, which in this case, as Mr. Roshan just said, are Uhava ballots sent by members of the armed services and Nevadans residing overseas. We also believe that keeping track of a chain of custody for all mail ballots will add additional safeguards to ensuring our elections remain safe and secure. Thank you.
Thank you, Ms. Guerrero. Appreciate your comments and taking into consideration. Mr. Moore, please.
Just using that same section 2.2. If in my understanding that a county clerk has the power alone without any observation to say, well, this one for me is not ambiguous. It's obviously for candidate A. And if that is the case, doesn't that give too much power to one person to interpret? Maybe that county clerk prefers candidate A over candidate B or something like that.
Thank you, Mr. Moore, for your comments. So again, ultimately, the clerks are responsible for a number of things based on the statutes. In these statutory responsibilities, there's a lot that they encompass. I will let you know that these sorts of adjudication boards, again, that look at it, while the clerk or registrar is ultimately responsible, the duplication boards are bipartisan teams that do the work at first and provide that initial assessment. So it is again, it's not, when in doubt, there's a stack of ballots and they go into a dark room with the clerk and then the clerk comes back out with an answer. Again, they want this to be a transparent process. They want everyone to understand that, again, it's a bipartisanship across the board, or really tripartisanship, I think was the term that was used before. So not just the major parties, but of course, all voters across the state do get a voice and a set of eyes in the process. But I understand your concerns, and we'll consider if there's a way we can maybe clarify it.
Well, I think we absolutely do, because for those of us that firmly believe that there was abuse in other states, I'm not familiar enough with Nevada, being a new citizen of Nevada, but it happens, and we saw it happen, and it was quite public in many forums that people at the machines were saying, "Oh, this is definitely for my candidate." They didn't say mine. I don't want to use names, but it happens. So we need to make this a foolproof, absolute, positive action to prevent that any one person. And I understand what you're saying. I think I understand what you're saying. You're saying that at the end of the day, the clerk says, okay, my team has been comprised of bipartisan people or tripartisan, and they have said, yes, we agree that there is no ambiguity here. This person used the corrective tape. They voted for candidate A, and even though I'm a candidate B party person, I agree that that one was candidate A. Is that the process we're saying is here?
Yes, sir, that is. And I will clarify also one last part of that, just to help, because again, the concern that I think you'll probably get to next, if you haven't already, is that how do we standardize what is ambiguous, or what identifies voter intent? So we are formalizing the guidance at the state level so that all 17 counties will have the same operating principles and guidance as to what voter intent means. And voter intent guides are something that are already well used across the country. It's something that if you've ever used a Scantron test before, you can imagine it's kind of an example where it says, if you see, if the voter circles and circles and then crosses off one with an X, well, that means they don't want the one with the X. And by having this standardized guidance from the state level to all the counties, so that they can provide that same standardization guidelines to their teams, and we're all operating on the same page, and there's clarity in regards to what that voter intent looks like. And those voter intent guidelines. In fact, the elections procedure manual in general will of course be a public document as well for review and opportunities for feedback. But yes, sir. Thank you for your comments. Mr. Parks, please.
Thank you, Mark. Bruce Parks, Chairman, Washoe County Republican Party. I see that the language has not been cleared up in this regulation to include, or I'm sorry, to remove persons and replace it with citizens. That is a very, very important distinction that has not been made in this. Is there a plan to edit this so that it does reflect the word citizen and not person?
Yes, sir. Thank you, Mr. Parks. I appreciate your comments. So we're going to view this holistically in the recommendation from Ms. Thomas in regards to considering throughout the entirety of really, again, all the regulations relating to Title 24 to make sure that if appropriate, the word person is taken out and the word citizen put in. And NAC 293, for example, has 190 instances of the use of the word person. But there are some that are not required to be a citizen for observation and for other situations. So that instead of taking it one proposed regulation and modifying each one of these at a time right now, but only doing part of the work, we're going to incorporate that into a consideration for future regulations and do a holistic review of all regulations relating to Title 24 to make sure that, again, whether it's NAC 293, 295, 306, every one of the regulatory chapters gets an appropriate review to make sure, if appropriate, that transition can be made. But bottom line, as it currently stands, there is no plan to do that to this regulation currently, because again, the inconsistency of having one chapter, or really one portion of one chapter with citizen instead of persons, but not the rest, would create inconsistencies that we want to avoid.
Yeah, I understand what you're saying. As long as it's a universal change throughout the entire process, then yeah, great. Go for it. Thanks.
Yes, sir. Thank you. Ms. White, please.
Thank you. Could you spell out, let us know in the chat, please, where it's in NRS or regulation that spells out the actual process for duplicating ballots? Does it include language in there that says bipartisan that would prohibit just one person from duplicating ballots? It should be really spelled out who and how that happens. And then the second thing is section 5.4. And it says, if those members do not interfere with the handling of the ballots. Well, interfere. I've seen administrative regulations and policies that would actually just allow, if the observer had the wrong look on his face, the clerk or whoever could say, well, I feel threatened, and they would consider that interfering. What does interfere mean? It should have some kind of definition that would restrict just how broad that definition can go. And then last section 5.2, emergency. And who can call that emergency? Is it only the governor, the secretary of state? Does it go down to the registrar of voters? Who has the authority to state that something is an emergency? Thank you.
Yes, ma'am. I'll see about getting you the answer in regards to the duplication board process. And we'll certainly take into consideration the question about interfere as well as the emergency to see if we can't maybe clarify that in this draft.
Yeah, it needs to be restricted in some way. And then just clarification on who can state what is an emergency.
Right. Yes, ma'am. Yes, ma'am. Absolutely. Thank you for your comments. We'll definitely take into consideration. At this time, is there anybody else interested in making public comment regarding proposed regulation R090-21P? Seeing none, I will close public comment on proposed regulation R090-21P and open the workshop on proposed regulation R091-21P.
I'm sorry, I couldn't hit the button fast enough, but there was another section here where it's talking about the voter had continuously resided in the precinct for which he is registered to vote for at least 10 days. Let's see. So how do they confirm that someone has been registered to vote for that many days or resided in that precinct? How is that determined?
The question about how long an individual is resided in a precinct, I'll confirm, but I believe it's based upon the voter registration date. Again, to be an eligible voter, you have to have an address, and that address again ties into the voter registration. Once they're an active registered voter, again, if that's been more than 10 days, then again.
Yeah, but they're same day registration now. So how can they confirm that they've actually been a resident for that long?
There are documents that you can provide that relate to proof of residency. There's also that's in regulation, I believe, as well as on our website too. But I can provide that as well.
Okay, so somebody walks up on election day and says, I want to vote, and they'll give them a driver's license, and you're saying DMV will have documentation and proof, good evidence that they've actually been residing at that address for that long, or whatever, utility bill or whatever. You're saying that those would have evidence of how long they've resided in that precinct?
Yes, ma'am.
Okay, thank you.
Yes, ma'am. Okay, for those of you following along, we are now starting the workshop on proposed regulation R091-21. This is on page 63 for those following along in the text, excuse me. Existing law requires the Secretary of State to adopt regulations for the conduct of elections in the state, which must include regulations prescribing 1, the procedures to be used to ensure the security of the ballots, 2, the procedures to be used to ensure the security and accuracy of computer programs and tapes used for elections, and 3, the procedures to be used for the testing, use, auditing of mechanical voting systems. Sections 1 and 10 of this regulation require each county clerk and city clerk to submit to the Secretary of State a written contingency plan for 1, the election operations in the event that the election operations are significantly disrupted, and 2, the tabulation of ballots in the event the county or city, as applicable, experiences a loss of central counting equipment or the use of the central counting place. Existing regulations 1 define the term ballot stock to mean the material upon which a ballot is printed and a voter directly indicates his or her vote. 2, provide that the Secretary of State will reimburse the counties for the cost of the basic stock per ballot. 3, require a city clerk or order ballot stock for an election within 2 days after the date set for the close of registration for the election. Sections 2, 8, and 11 of this regulation provide that the term ballot stock also includes the materials included with the mail ballot, including without limitation, the mail ballot, return envelope, privacy sleeve, and voter instructions. Section 3 of this regulation replaces the term stock for ballots with the term ballot stock. Existing law requires a county or city that wants to change or improve a mechanical voting system or mechanical recording device to first obtain approval from the Secretary of State. Section 5 of this regulation prohibits the county or city clerk from installing any software on a mechanical voting system unless the Secretary of State has approved or required the installation. Section 6 of this regulation requires each county clerk and city clerk to maintain a written documentary record for mechanical voting systems, mechanical voting devices, and other voting equipment, which includes records of transports of mechanical voting systems, mechanical voting devices, and other voting equipment, and chain of custody records for mechanical voting systems, mechanical voting devices, and other voting equipment. Section 6 also requires mechanical voting systems, mechanical voting devices, and other voting equipment to have tamper evidence seals identified with serial numbers, which must be recorded and verified in the records of the county and city clerks. Section 7 of this regulation requires each county clerk and city clerk to keep mechanical voting systems, mechanical voting devices, and other voting equipment in a secure and controlled facility when not in use, and to maintain a record of any person who accesses the mechanical voting systems, mechanical voting devices, or other voting equipment. If there's any unauthorized access, Section 7 requires a county or city clerk to inform the Secretary of State in writing within 24 hours. Existing regulations require that each county clerk, not later than the 90th day before primary elections, submit to the Secretary of State for approval a plan concerning the procedures to be used to ensure the security of the ballots, results cartridges, and voter verifiable paper audit trails, or VVPATs. Section 8 requires the plan to also include procedures to be used to ensure the security of election media cartridges or memory devices, blank ballot stocks, chain of custody records, and access controls. Section 8 further requires the county and city clerks to ensure that election board officers who are allowed to handle ballots, results cartridges, and VVPATs have sworn under oath to perform their duties honestly and faithfully. Existing law requires a copy of each election computer program to be filed with the Secretary of State at least 1 week before an election. Section 9 of this regulation requires that the copy be filed in certain electronic formats with password protection. At this time, I will open public comment on proposed regulation R091-21P. If you would like to provide public comment on proposed regulation R091-21, please go ahead and indicate in Zoom now. Mr. Parks, please.
So many problems with this, but the main one being, if you don't have access to the source code for the machines, how can you certify that the results are accurate? It's impossible. I don't understand why it's so difficult to understand that very simple concept that these voting machines, since the software is proprietary and we can't access the source code for the software, any certifications or anything else that we do is, I mean, really, Mark, it borders on the ridiculous to me. But I don't see any way to fix that except for eliminate the machines entirely and go to a paper ballot. Your thoughts, sir? Thank you.
Yes, sir. Thank you for your comments. Certainly take into consideration. And just to clarify, that there's no requirement from the Secretary of State or by statute that we use machines. It is a county decision. There are provisions that talk about paper ballot use, and we continue to research and discuss a multitude of different changes to the electoral process across the state to make sure that we can comply with statutes as appropriate. But yes, sir, I understand your concerns. It's certainly something that we've been discussing at length. And we'll take into consideration.
If I understand you, what you're saying, each county can make the decision whether or not to use the voting machines. The Secretary of State is not mandating that those machines be utilized. Is that a true statement, sir?
Yes, sir. The counties are the ones that make the decision. The Secretary of State has statutory authority over if a voting machine is used, then it must comply with certain statutes, and she's ultimately responsible pursuant to NRS 293-124 for the execution and enforcement. But yes, sir, if a county, really, if the clerk in discussions with their with his or her board of county commissioners or board of supervisors is appropriate, make a determination to do something different. Again, are there, then yes. Again, at the state, we're here to support the electorate and the needs of our clerks, and again, all the way down to the county level. So yes, sir.
Thank you, Mark.
Mr. Benton, please.
Oh, thank you, Mark. Oh, my concern is basically the same as Mr. Parks. Certifying new machines, I don't see how the Secretary of State can do that without the source code. And another issue that I'd like to bring up, that even if the Secretary of State certifies a machine, there are hundreds of machines, and even if one had a problem, it might not be reflected in what the Secretary of State saw. And then even one machine with making a few mistakes could change a possible election. For example, in Washoe County, there was one election that was decided by 10 votes. So I'm concerned about not having access to the software, not being able to review any changes. I just don't see the transparency to voters. Thank you.
Thank you, Mr. Benton. Appreciate your comments. Mr. Moore, please.
Yeah, I want to start off just by echoing, it's insane that we say, well, this is not important to us as either voters or even as the bureaucrats. We absolutely need the source code. We need the proper path forward that if there are questions, we can have third parties audit it and tell us what's in that source code. Like when we learned that there was such thing as a fraction of a vote in many jurisdictions, if not all 50 states, that should be a big clue that that things are being manipulated. And how do we know that if we don't have the source code? That was not my major point for raising my hand, but I need that to be absolutely noted down, that it's the most serious point that I see so far. The main reason why I raised my hand is the ballot stock. Are our ballots watermarked or protected against counterfeiting in any way?
Yes, sir. So the ballots, the paper that is used, the ballot stock, again, is not just your routine 8.5 by 11 paper that you can print out. And depending on the systems, whether it's if you're in Carson City or Lander and use those machines, that paper is again very unique and cannot be. It's not the sort of thing you just buy and bring in and stuff into a machine and expect it to work. It will not. But yes, sir. There are no there are no watermarks on it that I'm familiar with, but it is a unique type of paper, and there are certainly some security measures that we put on it to make sure. Again, right. Also, it's important to state that every ballot is associated with a registered voter. So if somebody is an active registered voter, they can vote. If someone's inactive or canceled, they can vote once they update their information and become an active voter. But again, the idea that if someone brought in 500 ballots and just kind of set them at a desk in a clerk's office, that wouldn't fly for a number of reasons. But yes, sir, your comments are noted and we'll certainly take into consideration when reviewing these in future regulations.
Thank you.
Ms. Thomas, please.
I just wanted to thank you for getting this, the standardization among the different counties of the best practices that have been employed for years, and that can be kind of standardized against all the counties. So everybody's kind of on the same page. I also like it that it addresses the various forms of media that is used within our elections. Because before, when the statute had very limited verbiage, then a lot of the resources that we do use in elections were basically not addressed and didn't have to be addressed. So I like that this is forcing those things to be addressed and uniformly and across all the counties. Thank you.
Yes, ma'am. I appreciate you recognizing that. Again, that we put in a lot of hard hours and continuing to make improvements across the board. Again, the goal from the secretary on down through every one of your clerks and registrars is identify room for improvement and then make it. So yes, ma'am. And that's not a finish line of the primary or the general or even 2024 or 2026 or 2028. Like, we've got some long-term goals and continuing processes that we know need to be improved, and we will continue to do so. But thank you for your comments. Yes, ma'am.
I imagine it isn't a living document for sure.
Absolutely. Yes, ma'am. Absolutely. Mr. Parks, do you have another comment, or Ms. White, please?
Thank you. Up in the digest part, you have your first paragraph, 1, 2, and 3. And I'm having a little difficulty finding which section that is referring to ensure the security. If you could just give me the exact section and number that belongs to that, it would be helpful. There's a lot of language in here that's referring to ballots and paper and stock and all this. It would seem to me that it should have twice as much that describes how and what the procedures are for ensuring the security of the system. And I'm not finding that. So what I would like to see is the exact steps that are being completed to show that it is secure and that the machine system is being tested, and exactly what those tests are to confirm that the machines are secure. I mean, I think that's part of the problem where a lot of the distrust comes from, because all we're told is that, oh, the EAC said this company can go check it, but what are they checking? I mean, it would really be helpful for that. And then it says section 5 prohibits installing software. So as I understand it, a week prior, is that 7 days or 5 business days? No one is allowed to put any patches or installation of software on there. And so I assume there's language, isn't that right? Or am I?
No, that's at all, ever, period.
Okay. And so the machines then are secured, I mean, with some kind of tamper-proof, I don't know, strip tie or whatever.
Yes, ma'am.
Okay.
Seals,
And
yep.
then section 7, it mentions, I'm trying to find it. Give me a second. Section 7, it mentions 90 days for something. I didn't finish my notes here. Oh, okay. I don't know where it is. Section 8. Why did I see section 7? Section 8, number 2, not later than the 90th day to ensure the accuracy and security of the voting. So it would seem that whatever document she is submitting to the Secretary of State should be available without an NPRA, and it should be available online, and that would help people, the public, understand exactly what measures have been taken to ensure the security of it. And when you say tapes, isn't that an archaic term? It was, I'm trying to understand where I saw it, something about tapes. Why aren't they saying drives? And they're saying cartridges and tapes. Is that peculiar to the hardware? Is that the terminology they use?
Yes,
Okay.
ma'am. The voter verifiable paper audit trail is on a spool of tape, paper. So that, I believe, is what they're referring to. But yes, ma'am.
Okay. So can you tell me which part of this regulation addresses those mentioned in your digest 1, 2, and 3? And could you put that in the chat for me, please?
The existing law part, ma'am, just to clarify, which part are you referring to now?
Okay, if you go up to the digest, and let me get back up there, and your first paragraph, 1, 2, and 3.
Oh, I see.
Okay, so I don't know where that is. I see the NRS, but where are those things addressed in this regulation, or
I
are there
see.
separate regulations?
Yes, ma'am. That's the existing law requires those regulations to exist again across. So that in other regulations as well. So not just this one, but that it's defining the authority that the secretary has, the requirement rather to make those regulations.
Okay, so where are those regulations?
The rest of them would be in NAC 293 and 293B. Which relates to mechanical voting systems.
Are you putting it in the chat?
Yes, ma'am.
Thank you.
And to clarify, first of all, I appreciate your comments. Definitely making some notes on that. Your desire for increased details across the board in regards to not only the nature of the testing, but the results are something that the secretary has already highlighted, and it's a goal that we are going to continue to work for. Again, incremental steps as we move along, but certainly the goal is to, again, you're absolutely right. If we're testing something, we should be able to explain what we're testing to help reassure voters. The results of those tests, good, bad, or ugly, should be public record on our website in a single location to make it easily identifiable so that you can look at the aggregate of all 17 counties as well as individual reports as well. So these are all things that we're absolutely considering and finding ways to implement going forward. Okay,
and is that something that we can look forward to for the 22 primary and general? Because as you know, I mean, if I had the ear of the Secretary of State, I would say, you got to do this now, because this upcoming election is so critical in the minds of so many people as far as its trustworthiness. That should be like priority one.
Ma'am, I will tell you, we have a lot of priority ones, and there's a lot of things that we're working frantically, not frantically, wrong word. We're working very aggressively to do. Without going into, again, staffing discussions, I will let you know that the secretary, again, is very clear in understanding the priorities and making sure that the staff are working to our fullest capacity to achieve her priorities. So yes, ma'am. Transparency, again, when you think about the multitude of hours, hundreds and hundreds of hours that we've spent on these regulations, I think we're roughly what 15, 20 hours or so of adoption hearings and workshops. This is but a fraction of one effort to increase transparency and to rebuild voter confidence. So yes, ma'am. I can assure you we are working hard on that.
Thank you. But as I understand it, you're saying probably not for the 22 primary in general.
And as you may have seen already, there are websites that we've added in regards to regulations, in regards to petitions, in regards to the election. We are increasing our information out there. Will it be all of the things that I want to have publicly available? Hopefully, that's certainly the goal. But again, recognizing again a number of limitations, I can't make any promises. I suppose that I will likely again we will have improved, but we will not be where I want to be. I believe probably by the primary election, very latest.
And how can I keep up to date with those new pages or whatever that you have on the website with the increased transparency? How can I keep up to date with that?
Absolutely. And again, I'm glad you asked. You'll notice, for example, on the 2022 election page that I just put into the chat, at the top, I've added the date that it was updated. And we're going to do that going forward so that at a moment's glance, I wouldn't expect someone to go on here, scroll down every morning, try to look for changes. If there's changes, you're going to know because the date's been updated, and then you'll be able to scroll to the bottom and see what the new information is. As we continue to expand the information across this and other pages, we'll have that there as well.
Okay, that's great. Thank you.
Yes, ma'am. Mr. Parks, please. Mr. Parks, do you have a comment regarding proposed regulation R091-21P? Mr. Moore, do you have one relating to this regulation?
Yes, this and any other. What I don't see under each one of these sections is a curing process when there is something wrong. So for instance, earlier there was a regulation that said who can go into a certain room or who can have access to X, Y, or Z. But I don't see anything that says what happens if and when somebody breaks that rule. What is the curing? Where do we find how that is cured?
So I'll have to review the regulations and procedures in the procedures manual and see if it's in there, and I can let you know. But if not, then I'll certainly take that as a recommendation to make sure that we do include something like that.
That would be great. And I would do it systematically on every. It doesn't have to be every section. It has to be every section and regulation that says something is forbidden or something must be done in a certain way. And then we must have, and if not, this is the cure, because 2020 showed that even when certain obvious fraudulent acts were taken, the very next question was, well, it's too late, we can't do anything, it doesn't have any influence or any of the systematic ways to steal an election.
Yes, sir. We made note and taken into consideration. Mr. Benton, please.
Along with that, I was wondering if that notice could be like an affidavit, so that it would be like more of a legal document. Thank you.
Thank you, sir. At this time, is there any other public comment relating to proposed regulation R091-21P? Mr. Mann, please. Mr. Budman, sir, do you have some public comment relating to proposed regulation R091-21P?
Can you hear me, Mark?
Yes, sir, I can. Thank you.
Quick question on section 7. It states that voting equipment will be in a secure and controlled facility when not in use. Do we have a definition for that, or what defines that? Is that something done at each county, or what is secure and controlled?
Yes, sir. Thank you for your question. Specifically, you're right. It is at the county level. Again, given county resources, the commissioners and the clerks work together to identify what that storage facility will look like. Again, going forward, I fully anticipate this changing and getting further refined as time moves on. But certainly right now, that ultimately is a clerk responsibility to identify in coordination with their county commissioners or board of supervisors.
So is that something, I know yesterday you spoke about it, is that something that would be a top-down approach that could be maybe brought forward in that approach where it's standardized through each county?
Sir, there's certainly been some discussion about that as well. And while the goal of standardization would require significant further coordination and collaboration with the state and county levels. As it currently stands, again, we identify the requirement, the clerks. I also agree, again, this is one of the things that I think a number of clerks that I talked to, brought up and wanted to add it into the regulations. But ultimately, I think I see what you're saying, and I understand. And again, like I said, there's been plenty of discussion about a standardized storage facility across each of the 17 counties. Based on their needs and requirements, right? Because of course, not every county has the same number or same physical storage requirement. But as at least stands right now, that's not something that's possible with this regulation. But it's certainly worth considering going forward.
Thank you, Mark, for your time.
Yes, sir. Thank you. At this time, is there any other public comment relating to proposed regulation? Ms. White.
Yeah, I'm not all up to date with everything that is used as far as external storage devices or cartridges or what else they may use. But anytime that is handled, any one of those storage devices, when a person has their hands on it, is it documented in here that when they had their hands on it and why they had their hands on it? I mean, even if they're carrying it 6 feet away, we should know who has touched that piece of external information or data. Is there anything in here that addresses that?
In this one, ma'am, I don't see it offhand, but there are strict chain of custody requirements. And I think that's what you're referring to. The chain of custody documents are again, there's an entire series of documents to talk about the requirements for that. What needs to be captured and how to make sure that there's no gaps that a machine or a device or ballots for that matter are not accounted for in a secure location or without it being known who has them. But probably not in this regulation, but yes, ma'am, those details are available.
Do you happen to know where?
I can get them for you. I'll take a note and get them to you as soon as I can.
Thank you.
Yes, ma'am. This time, is there any other public comment relating to proposed regulation R091-21P? If not, then I'll close public comment on proposed regulation R091-21P and open the workshop on proposed regulation R092-21P. In the text, I am now on page 77. Existing law requires each county clerk and city clerk who uses an electronic roster not earlier than 2 weeks before, not later than 5 p.m. on the day before the first day of the period for early voting by personal appearance to complete a test of the electronic roster to ensure its functionality in accordance with regulations adopted by the Secretary of State. This regulation requires the county or city clerk to also complete logic and accuracy tests on the electronic roster and to certify to the Secretary of State that the testing was completed not earlier than 2 weeks before, not later than 5 p.m. on the day of the first day of period for early voting by personal appearance. The tests required by this regulation require confirming 1, that the electronic roster accurately displays certain information, 2, the correct functioning of the electronic roster in certain situations, and 3, the correct performance of certain functions of the electronic roster. At this time, if you're interested in making public comment relating to proposed regulation R092-21, please. Proposed regulation R092-21P, please go ahead and indicate so in Zoom now. Mr. Mann, please.
Sorry, Mark, that was a bump. I apologize.
Yes, sir, no worries. Ms. White, please.
Our entire election, if you just get down to all the problems, you end up at the electronic voting system. But even more important than that is the registration of voter rolls. That voter roll is critical to everything. If you have a dirty roll, you're going to have a dirty election. And with the input of same-day registrations, it makes the voter rolls potentially dirty. It's just so critical. And I don't know, it doesn't matter how many regulations you write trying to keep it clean. As if it's changing over and over and over every single day, all the way up to election day, it's going to be dirty. It's going to be dirty. And so, I mean, I don't know what the solution is. I would like to see the entire voter roll cleansed, zeroed out, and people need to re-register every election. But I know that's not going to happen. But I'm just communicating my disappointment that there's not enough regulations in the world that you could write that will cure this, as long as we're working with old registration rolls. Thank you.
Yes, ma'am. Thank you for your comments. Ms. Martinez, please.
Yes, thank you. For the record, Cindy Martinez, Vice Chair of the Washoe County Republican Party. Mark, I'm going over, I thought we talked about an element of this yesterday, changing from 2 weeks to the 5 weeks. There's so many of these regulations are running around in my head, and I'm trying to correlate what we've already talked about, what you're proposing. Is this related to that? And then, of course, that goes to Valerie's point about you can write all of these regulations 7 which ways to Sunday, and there's no guarantee that any of these are going to promise the security of our elections. I'm just so dismayed by this whole, having worked with regulations in a state agency and understanding the interpretation and application of how they're used. For example, NGC Regulation 5.011 regarding unsuitable methods of operation, that was broadly interpreted by the governor to, this is just a point of contrast, compare and contrast, using that regulation to, I lost the word, but to levy punitive fines on the gaming industry under the guise of COVID. So 5011 in the Gaming Control Board was not intended for that, but it was interpreted. So similarly, these regulations, no matter how you tighten the language, depending upon who's driving the bus, is how they're going to be interpreted and applied. So circling back, unfortunate turn of phrase, are we talking about the same thing about the 2 weeks before, which I thought we had talked about 5 weeks before and a week before what we were talking about yesterday? I'm really confused at this point.
Yes, ma'am. And so to be clear, the timelines that we adopted yesterday are certainly going to be considered when looking at them through the lens of these regulations. This is, you're right, this regulation in particular reflects, I think, and just to clarify, there are already regulations that talk about the testing that has to occur for all the other voting systems. But the electronic poll book, right, the system, this part of the voting systems that has the roster on it, we recognize that did not have regulations that specify what level of testing should be done or needs to be done. Was that occurring? It was. Was it mostly standardized? It was across the state. You know, but this was something that we wanted to put into regulation, again, to clarify for everybody that it is being done, one, uniformly across the state, two, to clarify a little bit how it's what that process looks like, and to describe the timelines. And then, yeah, and three, I think you're right. Like the concerns about interpretation are certainly one that we're keenly aware of. And that's part of the reason why you've heard me mention this before, that this is not a one-off, one-time process. Like we're going to have these type of regulatory workshops and adoption hearings, really every, following every election cycle, so that we can continue to refine and develop and improve the clarity on what we're saying and how. And again, a lot of that's going to be based on clerk input saying, your timelines here said this, but it was, kind of squishy. I think you should solidify it, maybe more clearly define it. Hey, by the way, this test, that's actually an outdated test. We did it, but we had 3 others that were far better and more effective. Let's add those in as well. So that the public are aware of the different steps that are being taken, what that looks like. And that's also going to help, right? Because as I'm sure you're aware, out of our 17 county election officials, that we have the 2 appointed registrars. Out of the 15 others, 4 have already resigned. Others, at least 2, have identified that they're not running for re-election. So that as we receive, as new clerks are elected into office, again, having more clear, more defined regulations, along with the elections procedure manual we talked about, are merely going to be helpful tools so that a new clerk can step into office and again, has a very clear understanding of what needs to occur and why, to eliminate ambiguity or the possibility of any sort of deviation from the statewide standard. But yes, ma'am, in regards to the timelines, yesterday, we'll certainly be considering those when looking at this regulation moving forward after the conclusion of our workshops. But thank you for your...
So to your point then, so then it seems that this language then should be cleaned up to be to incorporate the 5 weeks before, not later than, see, I can't remember.
It was no earlier than 5 weeks before, but no later than 1 week before the start of the election, I believe.
Yes,
yep. Yes, ma'am. That's exactly what I was going to look at, and certainly something we're going to consider. Because you're right, the testing, there's a kind of a block period where the clerks focus on their testing and work through the systems. Yes, ma'am.
Okay, so there should be congruence then between this regulation and then the other one. So you're going to change that?
So yes, ma'am. Again, I won't commit to anything just yet, but we're gathering all the information from these workshops to get the feedback. I'll discuss the feedback with the secretary. That is going to be one of my recommendations moving forward before we get to the adoption hearing on this regulation.
Okay, and then if I may continue with one last point raised by your comments. So is there any point of accountability between the county clerks and voter registrar that you can ensure, and if this is the goal, so that there's compliance across from the county level all the way up to the state, which of course, let's just for the record, we don't agree with that. But is there a point of accountability where you catch that the county representative is not complying with these? I mean, how do you ensure that there's any compliance? If you don't have points of compliance or checklists and that sort of thing. And here again, we're talking about if you have such an infrastructure of accountability, I can't imagine that you have adequate staff to do that in addition to everything else you're talking to, unless your enforcement division of the Secretary of State is following up on these points of compliance, which if that's the case, then you need, needs to be some language about that, do you think?
Yes, ma'am. I understand your concerns in regards to compliance. Part of it right now is, of course, that there's reporting requirements to the state, but there are some discussions about what the elections division's budget proposal will look like before the 2023 legislative session. Those, of course, will still be determined and still need a lot of further analysis before we get to that point. But certainly when we think about staffing requirements in light of the increase in election legislation and those sorts of things, that's something we're taking into consideration as well. Because you're right, like having a rule without any means for compliance or the staff to review them to make sure there is compliance, it would basically make them ineffective. So yes, ma'am, keenly aware of that.
Exactly. And thank you.
Yes, ma'am. Mr. Mann, do you have a comment on this one?
No, Mark, thank you.
Sir, Ms. Thomas, please.
Thank you. I just wanted to, first of all, if you could mute this Belinda Aragon. I have tried to private message her to thank you. And then also I just wanted to again reiterate, thank you for standardizing best practices that are already being practiced within the counties. And again, contributing a uniform process for the intake stations and establishing a living document, so which also provides more transparency of the intake process and the media that we use in that process. Thank you.
Yes, ma'am. Thank you for your comments. Ms. White, please.
And I hope I have not gotten confused. I had an interrupting phone call, but when you're talking about the polling books, wouldn't they be considered part of the system that is supposed to be ensured as far as the security and the accuracy? Would the polling books be considered part of that?
Yes, ma'am. So again,
Okay.
that's part of why we include that. But again, we wanted to specify and draw it out in a separate regulation so for transparency and to make sure there was no ambiguity.
Okay, so just as some of the hardware, well, not just hardware, the risk limiting audit that we talked about yesterday had a 5% number that would trigger something else, a review of the hardware, software, whatever. It seems that there should also be a risk limiting audit for the accuracy of the voter registration roll. If more than 5% of the voter registration roll is bad or dirty, what is the solution to fix that? A risk limiting audit, that would maybe be a canvas. I don't know, but if the polling book, which contains the voter roll, is part of the overall system that the Secretary of State is ensuring us is secure, then it should be risk limit audited as well.
Yes, ma'am. Again, I appreciate your comments. In regards to the maintenance of the statewide voter registration list, we are nowhere close to being done identifying means to improve, to validate, and to continue to reconcile that. Of course, we are confined by federal and state laws, so that certain things have to happen again and are happening as fast as they can. Again, recognizing federal and state laws that we're operating under, but there are still a number of things that we're looking at and ways to improve everything from resources to funding that might be required to different processes, new ideas similar to what you're talking about, like a risk limiting audit and other types of reviews to help further enhance the clarity and cleanliness of our roles. Yes, ma'am. That's we could have a week's worth of discussion on that, and I very much enjoy it. If you ever have any suggestions, please email them to me direct, and I will be more than open to discussing and hearing your ideas.
Okay, I'm just confirmed that digest, that 1, 2, and 3, NRS 293.247, which is telling us to trust the system because they're guaranteeing that they're looking at the security and accuracy. The poll books are part of that system, and so there is no trust, or there's no security or trust in it. And it needs to, since it's part of the system, which you just said, yes, it is, then it needs to be accurate as well. And it's not. So I don't know. I mean, the only way that you're going to make sure that that is a good voter roll is if you have in-person voting or voter ID and paper ballots. Paper ballots would solve that solution as well. But the electronic voter registration roll is beyond help. It's DOA. Thank you.
Yes, ma'am. Thank you for your comments. At this time, is there anybody else interested in making public comment regarding proposed regulation R092-21P? Seeing none, I'll close public comment on proposed regulation R092-21P and open the workshop on proposed regulation R093-21P. I am looking at page 84 of proposed regulation LCB file number R093-21. Existing law requires the Secretary of State to adopt regulations relating to elections. Existing law provides that it is unlawful during early voting or on election day to electioneer inside of a polling place within 100 feet from the entrance of a polling place. Existing law also requires the county and city clerk to ensure that certain notices relating electioneering are posted at the outer limits of the area within which electioneering is prohibited. Sections 2 and 11 of this regulation interpret the term polling place for the purpose of such electioneering statutes as meaning a place designated by the county or city clerk for the purpose of voting by personal appearance. Existing law authorizes an Indian tribe to submit a request to the county or city clerk for the establishment of a ballot drop box within the boundaries of the Indian reservation or Indian colony for the day of certain elections. If the county or city clerk establishes such a drop box, existing law requires the county or city clerk to continue to establish a ballot drop box for the day of any future primary election, presidential preference primary election, or general election unless otherwise requested by the Indian tribe. Sections 3 and 12 of this regulation require the request for the establishment or removal of the ballot drop box within the boundaries of the Indian reservation or Indian colony to be submitted to the county or city clerk on a form prescribed by the Secretary of State. Existing law establishes various requirements relating to ballot drop boxes. Sections 4 and 13 of this regulation require the county and city clerk to affix each ballot drop box with a unique identifier and the county or city seal or similar design that signifies that the box is an official ballot drop box of the city or county. Sections 5 and 14 of this regulation require the county and city clerk to submit a list to the Secretary of State of each ballot drop box established in the county or city. Sections 5 and 14 require the list to include 1, the unique identifier of the ballot drop box, 2, the location of the ballot drop box, and 3, the dates and times during which the ballot drop box will be unlocked and accessible for ballot submission. Sections 5 and 14 also require the county and city clerk to submit an amended list to the Secretary of State not later than 24 hours after a change is made to the information contained on this list. These lists, by the way, just to put it on the record, will be put on our website as well and made available to the public, likely on that same 2022 election information page, so that they're easily accessible to everybody, along with a similar updated comment in case there are changes. And the intent there, of course, is by knowing where the drop boxes are, that'll help facilitate their use, as well as having designated numbers on them that will help facilitate improved reporting. We noticed and heard from other states that have used ballot drop boxes that if you don't have a numbering system on them, then you end up getting a lot of phone calls. Hey, there's a ballot drop box in the city that's it looks like it might be full. And then without knowing, again, you have to kind of check, and it delays the ability to take care of that and address that issue if it emerges. So this is intended to help facilitate that. And the clerks are also considering everything from identifying the high use boxes and then establishing schedules for the bipartisan teams to empty them or replace them, and a number of other things. Sections 6 and 15 of this regulation establish various provisions relating to the security and accessibility of ballot drop boxes. Sections 7 and 16 of this regulation require the county and city clerk to submit a plan to the Secretary of State that relates to ballot drop boxes that are tampered with or rendered inaccessible. Sections 8 and 17. And again, the intent there is also so that we've thought about this beforehand, right? Like, again, we don't want to get to a point where a or multiple drop boxes are either tampered with or rendered inaccessible. And then only then during the election, try to consider what to do with it. We're going to have this plan in place well in advance. So that's been thought through. Sections 8 and 17 of this regulation require the county and city clerk to establish retrieval teams for the purpose of collecting and transporting mail ballots from ballot drop boxes to the receiving center or to the central counting places directed by the county or city clerk. Sections 8 and 17 also establish the time frame in which such retrieval teams must collect the mail ballots from the ballot drop boxes. Finally, sections 8 and 17 require the retrieval teams to submit a form to the Secretary of State, which describes the chain of custody of the mail ballots collected from the ballot drop boxes. Sections 9 and 18 of this regulation require the county and city clerk to submit a report to the Secretary of State not later than 45 days after each general election. Sections 9 and 18 require the report to include the costs associated with 1, purchasing, installing, and performing maintenance on ballot drop boxes, and 2, the retrieval teams. Those reporting requirements in section 9 and 18, again, for your awareness, are part of our continued effort as well. There have been changes, as I suspect you're all well aware of, in how our elections are conducted and some of the resources required to conduct these elections. By requiring certain reporting metrics, as indicated in sections 9 and 18, that's going to further enhance our ability to not only discuss and refine regulations, but also, again, provide increased clarity on our fiscal notes and other feedback as possibly required by legislators going into the 2023 legislative session. At this time, if there's anyone interested in making public comment regarding proposed regulation R093-21, please go ahead and indicate so in Zoom now. Ms. Thomas, please.
Thank you. Thank you once again for submitting documented procedures for best practices amongst all counties. So all counties are doing the same thing. And then also I have a comment on section 6, item number 3. You have accessed the ballot drop box for ballot submission on weekends and during evenings. I propose to have that struck, and because basically the county clerk must take actions necessary to ensure that persons have adequate opportunity to ballot submission to the drop box during early voting and election day. That should be sufficient because that is the time when those drop boxes are available. During those periods which are posted, the times that they're available, and early voting does go for, well, I'm not sure if there's any legislation has changed it, but it was for 2 weeks nonstop. And that included the weekends, and the hours, you know, for Washoe County, I think were 10 to 6 or 10 to 7. I can't really remember exactly, but that should be sufficient. Just the county clerk must make actions to make sure that it's available during early voting and election day. If you put in weekends and during evenings, people are going to interpret that to be it's going to be available 24 hours, and that's not necessarily the case. Thank you.
Thank you for your comments, ma'am. Ms. Tiger, good morning, please. Ms. Tammy Tiger, do you have comments relating to proposed regulation R093? Yes, ma'am.
Sir.
Please.
One moment. Okay. Thank you. Thank you for the opportunity to provide comment. I would like to just state that on sections 3 and 12, do not provide access to the form by tribes. City and county officials to distribute the form to the tribes can help to improve awareness about this new option for voting access. The recommendation that I have is that you add language to each section requiring the county and city or city clerk to distribute the forms and make them available on their website as well. If the clerks could identify that tribal, being that tribal nations have a sovereign nation-to-nation relationship with the federal government, that our tribal administration buildings are considered government offices that are secure to host ballots drop-off boxes to make it more accessible for the tribal residents who are quite often in rural areas. Not only are there great distances from having access to cast a ballot, but also to their post office. Even just getting to the post office could be an hour drive if they were to mail. So we just wanted to bring those to your attention and ask those that you consider those with the language. Thank you.
Yes, ma'am. Thank you for your comments. We'll certainly take them into consideration. Ms. Guerrero, please.
For the record, my name is Matilda Guerrero. During the 2021 Boulder City municipal election, 2,336 out of 4,079 registered voters casted their ballot by mail. That means about 57% of the voter turnout preferred to complete their constitutional right to vote by filling out their mail ballot and submitting it at either by mail or dropping it off at a designated ballot drop box. So it's great to see that this regulation spells out the exact rules our election officials and workers must follow to make sure that every vote is counted.
Thank you for your comments, ma'am. Mr. Moore, please.
Hello. Yeah, just a quick comment. It's not every vote that counts. It's every legal vote that counts, with all the definitions behind that we all should be aware of. Anyhow, back to the drop boxes. I want to start off by saying, again, no machines, no drop boxes, no mail-in ballots. Let's just make an election paper ballots, you have to be there, end of story. But I want to go ahead and understand, since we can't change the legislature now, we're dealing with how to at least protect the maximum we can under the legislation that we have. And I don't understand, for instance, why we even need drop boxes. If the idea is, okay, the person cannot come in person and they cannot mail their ballot, is that why we say we need drop boxes? And what kind of person or what kind of situation, maybe with the exception of the these Indian territories that are very remote, okay, perhaps there is something like that, but what is the purpose of these drop boxes?
Mr. Moore, thank you for your comments. This regulation relates to the implementation of drop boxes because they're required pursuant to Senate Bill 321.
Okay, so let's say, okay, we're given that we have to fight on a different front in order to change that. But given that we need drop boxes, I'm a little bit confused how long these drop boxes are, let's say, open for business. When these people that choose not to go in person, scares me, not to go through the post office, scares me. These people can only go during a certain amount of hours on one day or several days. I'm confused about that.
So the regulations are simply clarify the employment of drop boxes and how the ballots are going to be collected from them. In regards to their use, there are individuals, again, across the state who have expressed distrust in the Postal Service. This is another means for them to drop off a ballot. Again, the regulations are really focused purely on because Senate Bill 321 requires the use and employment of drop boxes, simply providing guidelines on what that looks like for standardization across the state.
Yeah, but how many hours, how many days? That's I'm missing that. I know it's in there somewhere, but it's just too difficult for me to catch that.
Yes, sir. What I'll do is I'll draft a summary and I'll provide that to you separately to explain the timelines and some of the other details.
Okay. On another subject, on this 100-foot no electioneering, 100 feet. If it's so important to prevent electioneering during the in-person voting, isn't 100 foot very minimal? I mean, can't we see 30 yards away from us anyhow? Is that something that's given? Is that something we can change here? If it should either be 0 or it should be, at least 1,000. I don't understand how 30 yards makes a difference.
So that's defined in statute. I just copied it into the link or into the chat rather. NRS 293-740 states, except otherwise is provided, it's unlawful inside a polling place or within 100 feet from the entrance to the building. So that it's a statutory requirement.
So again, we have to go a different route to address that. Okay. And my last question, I'm sorry. In section, I think it's section 6.2B, section, let me find it now. Yes. So in section 6.2, in addition to any requirements set forth in subsection 1, if the county clerk or an employee of the county clerk is not constantly present at the location of ballot drop, the county clerk, and then on B, it says may survey the ballot drop. Why is it may? It should be, well, either it is somebody is physically there to assure the integrity of it, or they must, or they shall ensure that it's videoed. And we know that that's important because of the videos that were captured in Georgia and other states of ballot stuffing.
Yes, sir. I apologize for that. I was taking some notes. So in regards to May, this is something, again, that I anticipate will likely change in the coming years. When we discuss with other states how they do their surveillance of ballot drop boxes, we got a really good amount of feedback, but it came with a hefty price tag. So currently the requirement is shall, in part because a number of the counties across the state do have visibility on their drop boxes. In fact, those drop boxes will only be available inside of polling locations for the most part. So again, may now, because some of the counties have expressed interest in pursuing that. Going forward, depending on resource allocation and budgetary requests, a number of other factors, that you're very right that may change to shall or something else. But as it stands here for the first step, again, including something to allow it so that way, again, if a county does surveil their drop boxes, that there's no questions about the legality or why that was allowed or authorized. It now is clearly, they may if they choose to. But going forward, again, that will continue to be the subject of further discussion.
But as a workshop, don't we have any? I feel like these are nice conversations around a beer in a bar, even though I don't drink beer. But anyhow, I don't really get the sense that our inputs become really more insistent that we want these things changed. For me, the difference between may and shall is day and night. And if a county says, well, we can't afford it, then don't do ballot boxes. End of story. It's really frightening that we know we have fraud in the nation with ballot boxes. We know that video helps, although I've never seen anybody really arrested or charged or have any curing of the votes. It's really frustrating. This whole process is frustrating because, you know, I think most of us, I won't say most of us, at least I am saying, I don't like the entire system of skirting around, you know, voting. Voting is the most important thing to us. And we say shall or may is important. It must be shall. It must be no ballot boxes. But since that's legislature, I can't change that. But my understanding is this workshop, we can change that wording. We should change it to shall or no ballot box.
And so just a reminder, well, one, I appreciate the comments and we'll certainly take it into consideration. But two, we can't create regulations that conflict with the statutes. But again, take into consideration and we'll see what we're able to come up with by the adoption hearing on February 22nd.
Thank you.
Sure. Ms. Martinez, please.
Yes, thank you. For the record, again, Cindy Martinez, Vice Chair of the Washoe County Republican Party. As I read these regulations, I am viewing these from the context of my own experience at the Gaming Control Board and the understanding of minimum internal control standards and internal control procedures that are the means by which casinos are required to comply in processing drop times, exceptions to drop times, the composition of the drop teams. And while this is a good start, I think some of the things that need to be tightened up is that the retrieval teams should not be related to each other. I do know that in some circumstances that we had married couples, and sure, you know, I want to work with your spouse all day. I don't know who would, but that's a problem. You need to have some independence between membership on those retrieval teams. The other thing I would say is that I know in my own work as a poll watcher, that was the first thing that I looked for on all of the drop boxes at the locations I was stationed, was that there was no serialization. There was no, there's only one single lock. There should be double locks. And the other thing that was problematic is the intake for the ballot boxes. I saw in some circumstances and also heard anecdotally from other locations where that person was using a stamp. You know, you adjust the date received November 3rd, 2020, and you stamped it. Some locations didn't have a stamp, and so the person was writing the date on the envelope. None of these means of ascertaining when these ballots were actually received is free from manipulation. So I don't know how you change that unless you have one of those automatic, like they have at the casinos, the time date stamp that's calibrated every day. I mean, we're talking about multiple layers, again, of verification, regulations that leave the process out of local control. Okay, having said that, that's where we're at. So those are the points that need to be tightened up. You know, you need to establish degrees of consanguinity of people who can be working together on polling places, or rather the retrieval teams. There's just so many. Nothing is more valuable than my vote. Okay, and viewed from the point of the Gaming Control Board regulations on the casinos, there's more control on the transfer, drop and transfer and count of money than what's happening here with our sacred vote. That's all I would say about that. Thank you.
Yes, ma'am. Thank you. I've taken solid notes on those, but we'll definitely take those into consideration and see what we can do. Ms. Ramos, please.
Thank you. Again, for the record, this is Mary Janet Ramos with All Voting Local Action Fund. And I wanted to state for the record that I agree with Mrs. Tiger's comment. I would also like to add that Nevada Native voters showed up in the last election, but remain undeserved by county officials. Prior to 2019, tribal governments did not have the option to request a polling place. And in 2016, the Pyramid Lake and Walker River Paiute tribes had to sue the state of Nevada in order to receive accessible polling locations for their voters. The Native American community has suffered voter disenfranchisement for far too long, and it is past time that election officials do more for this community than the bare minimum. Clerks must remove administrative barriers to better and more equitably serve Indigenous voters, especially in light of Nevada's new voting laws. Nearly 70% of American voters in Nevada live in rural areas, and they overwhelmingly used mail-in voting in the last election, and 13% opted to vote in person on election day. With this being said, we would like to add the following recommendations on Section 3 and on Section 12. And for Section 3 to read as follows: the county clerk shall distribute a request form to each Indian tribe located within the county no later than 60 days prior to each election scheduled to place within county, and additionally at the request of the Indian tribe. The county clerk shall make the form available on the county's website and on the county clerk's office. For Section 12, it is similar language, but we have replaced county clerk to city clerk. Thank you.
Thank you, ma'am, for your comments. We'll take this into consideration. Just a reminder, by the way, while I'm thinking about it, I really appreciate everyone's, again, extending, mutual respect and dignity to each other so far verbally. I would just remind you again that the chat for Zoom is intended so that people can identify if they have a public comment to make, and not for any discussion about other members of who's involved today. So again, please be mindful of that. If you want to take things on a sidebar out of the chat, I encourage you to share information so you can continue to do so on any number of other social media platforms. But please, again, the chat is so that I can see if somebody's interested in making a public comment, and not to discuss funding sources that do not relate to these regulations. Ms. Thomas, please.
Sorry, I got to reading further down here. Under Section 8, Item 2 on page 89, I would like to request that if practicable be struck. It should be at all times, members of every part of the process of elections should be managed by different political parties together, a team of different political parties. And then also down on Section 4, number A, you have that they are going to hand the last person in line at the close of polls a card prepared by the county clerk of statutes that states the last person in line. And I would like to have added, and the clerk shall note the name of that person the card is given to. Otherwise, that card is just going to be passed on down the line. Traditionally in Washoe County, we've always had to have one of our staff stand at the end of the line to regulate that. So I'm glad that the card idea helps free that person back up to be back at the intake station or managing the machines or the kiosk, the voting kiosk. So, but I would just like to also have it added that they get the name of that person noted so they know the correct person has the card by the time they get to the front line.
Yes, ma'am. Thank you for your comments. And that's, again, absolutely something that we'll take into consideration. There was a lot of discussion about this part of the ballot drop boxes to make sure that, again, at the close of the polls, that is when the ballot drop boxes are secured, and making sure that, again, it's like a mailbox, right? Like there's not, I don't know how many times I've ever seen a line leading up to a mailbox. I guess maybe once or twice, but in that rare circumstance, it's exactly what we're trying to capture, to make sure, exactly like you're saying, that there isn't, people submitting ballots past the deadline to consider them timely. So I appreciate your comments. Yes, ma'am. Ms. White, please. Ms. White, did you have any public comment relating to proposed regulation R093-21? Does anyone else have any public comment relating to proposed regulation R093?
Yes, I finally got it. I changed the size of my screen and I couldn't find the unmute. I'm sorry.
Oh, yes, ma'am.
Yeah, I have several. Okay, is there language anywhere in here that stipulates that observers are able to observe the collection process? And if not, can that be added? And this might require the registrar of voter to detail when the scheduled pickups are, so that observers can be available to do that. Bipartisan observers would be great. And you mentioned earlier that sometimes emergency pickups are necessary because a box is full. So the registrar of voters would need to notify some observers on site, or whoever's in charge of the observers there for whatever party, that a pickup, an emergency pickup is. So it would be nice if it was just stipulated that we could observe that pickup process. And then is there any language, any place that details that the pickup people must go directly to the drop box and go directly back to the county without any stops at Jack in the Box or somebody's uncle's house or whatever? It must be unbroken transport. Is there language in here about that?
I don't recall, but I'll certainly take that into consideration. Yes, ma'am.
Because that's just a real open opportunity for somebody to say, I need to stop at my house and pick up 5,000 more ballots. And just briefly, when there is a drop box, I'm assuming there's a bag or something inside. Do most counties have that? Because how are the ballots actually carried by the pickup people?
It does vary county to county. Yes, ma'am. In some cases, like in Clark County, for example, they actually pick up the entire locked ballot drop box and return it directly to the central counting place and replace it with an empty one. So that way there's no even ability for the individuals to get access to the ballot drop boxes.
Okay, so if standardizing the behaviors among the counties is what's desired, we should have something in here that said the transport may only be done in locked, secure containers, whether it's a bag or whatever, with a date and timestamp, preferably. There just shouldn't be any opportunity for anybody to stick their hands in there, add some, take some away, or whatever. And let's see. And if there's a drop box like in a grocery store and the grocery store closes, what happens to those drop boxes? Are they the entire box picked up, or where is it secured on site?
Yes, ma'am. So those situations don't occur. Again, as at least right now, they're in specific polling locations, and the boxes again are secured, whether it's overnight or whenever they're not available or in use.
Okay, so a pickup team would pick up the entire drop box and take it back to the county. Okay.
Yes, ma'am. And this is another regulation that we anticipate changing again after the 2022 election cycle. Again, really, right? Like our only experience was 2020 when we had the 4.5 million in CARES Act funds and significantly more people involved in the process. And Not as many individuals used the ballots and ballot drop boxes. So there was there were a lot of anticipated changes and a lot of a lot of close scrutiny that's going to occur across the state by the county clerks and by the elections division to identify some of these best practices going forward. But yes, ma'am, I appreciate your comments and have taken the notes.
So I'm not quite sure what you just said, but I guess you're referring that it's not going to happen in 2022. What is not going to happen?
Oh, no, I'm simply stating that these, your suggestions, again, some of them we are considering, some of them we anticipate needing more information about before we can fully standardize across the state. Every single aspect of every part of that process. So again, it hasn't been determined yet. There's still a lot of ongoing discussion and consideration about that. Certainly going to try to make them as tight as possible, but the bottom line is that this is going to be a continuing, ongoing development for this regulation.
Okay, I don't understand why it wouldn't be possible to make sure that the transport container is locked and secure from the moment that it's picked up.
Oh, yes, ma'am. So some of that will be incorporated in some of those, certainly considered. Again, I didn't mean every specific aspect of what you said is not going to happen.
Okay, and just going to 8.2 again. She wanted, if practicable, removed. And I'm just wondering, how are you confirming that you have differing political parties? What is the evidence? Just somebody saying, yeah, I'm a Republican, yeah, I'm a Democrat. That's not good enough. How can the registrar of voters or the county clerk or whatever confirm that's true?
I'll confirm that we have something in place. Again, there's a number of different questions that relate to that, right? I mean, how long would one have to be registered as a partisan with a party before it's enough or allowable? Because same day registration allows the change of party affiliation all the way up to day of. So
and that would not fly. I mean, so if I were a Democrat and I just walked up and I changed it on registration day to voter registration, anyway. Thank you.
Yes, ma'am. Ms. Thomas, please.
Okay, sorry. I just wanted to iterate, in Washoe County, the poll boxes were actually manned by staff, and there was also a laptop that they actually scanned each one of the envelopes. Although I am told that scan didn't really do anything. Is there any intent to apply scanners on these drop boxes so as envelopes are processed through them, that the barcode on that envelope can actually register a receipt of a ballot for that voter, that it would then sync up with the the poll books to know that a paper ballot has been received for that person? So then that person can't then turn around, go to a early voting location and then vote before the paper ballot has had a chance to be processed by so that's question number one. And then just to clarify, also in Washoe County, the teams did have bags. And so when they went to go collect, they opened up the poll boxes, and the team that is managing that poll box and the team that is collecting that poll box both validated or confirmed the number of ballots that was being picked up at that time. It was written on a piece of paper. Those ballots were stuffed in a bag. A numbered zip tie was put on that bag. It was recorded on that piece of paper. So all of that went back to the registrar's office. When the registrar's office received it, they verified that the same zip tie number is on that bag that was put on that piece of paper. So there is some chain of custody measures taken and that are put in place. So I imagine those are being shared across the counties as well. And then also as far as requiring teams to only pick up one poll box at a time and then immediately go back to the voting central, that would involve a lot more of these transport teams, because the Washoe County transport teams they were assigned to certain sections of the city. So there was 4 transport teams, and they went out and collected several poll boxes at a time. So again, with the process of putting all these ballot envelopes into their bags, and then the bags would go into the vehicles, and then they go to the next box and get them. So there was a series of polling locations they would go and collect these through, and then they would go back to the registrar. So they basically made this, they basically went and collected these envelopes, 4 or 5 times during the day, several times during the day, cleaning out them and taking them back. So if you are going to stipulate that there be no stops in between the polling boxes before you get to the registrar, I just wanted to make sure that these teams were allowed to go to several boxes in collecting before they had to go back to the registrar. But yes, there should be no stops in between those boxes. Thank you.
Yes, ma'am. Thank you for your comments. And just to clarify, yes, we did look into buying the modification to scan ballots when they get dropped into the drop box. There's still some discussion about that and some funding discussions that are ongoing. But in the interim, even without that, right, if somebody drops in their mail ballot into the drop box and then immediately walks into a polling station and votes in person, you're right, the mail ballot will not be recognized. They'll check in, they'll vote in person, and then when that ballot ends up getting back to the central counting place, as you know, and it's scanned, it will show in real time that individual has already voted in person, and then we will have caught them for violating NRS 293-780, which is a crime. So, and that ballot will not be cast. But yes, ma'am, there's a number of things we're looking at, ways to continue improving the security of the process.
I also wanted just to clarify too that the county registrar does, the poll workers are considered employees of the county, and one of the requirements to be a poll worker is you have to be a registered voter. So those things are checked before that poll worker is even allowed to work. So whatever they're registered to vote as, that's at the time that they are employed is what they are registered as far as, and how they are assigned to their polling locations according to the party that they're registered on. So hopefully that helps a little bit.
Yes, ma'am. Thank you. Mr. Moore, please.
Thank you, Mark. Are the transport teams, are they using their private vehicles, or are there specific vehicles that are obligated to use?
Sir, this question has come up before, and I believe there are some locations that use personally owned vehicles. We have a recommendation from, I believe, a previous workshop, as well as in some written comments that were emailed to consider adding in a requirement for county government vehicles only.
Okay, and in my mind, I think still of these armored vehicles that pick up funds and monetary things at banks or shops or what have you. It seems that a vote would be even more precious than even a Harry Winston diamond ring. So I would think that we want to go to that kind of system as soon as possible. Again, I need to preface, I'm against ballot boxes entirely, but until we change that law, I think at least we have to go ahead and put something in this, if we can, that obligates a certain kind of vehicle, and not a person's personal vehicle.
Yes, sir. Thank you for your comments. Taking into consideration. And again, those are the sorts of things too that at a county level can be influenced by the county commissioners and the county clerks and registrars. I know a number of the counties have mine resistant any armored vehicles, like an MRAP, that may be worthwhile, but and then again have those already in their use. So but yes, sir, you could also imagine, right, seeing an MRAP roll up to a ballot drop box that might also send a different message too. So, but certainly something we're taking into consideration and trying to figure out a best practice for. Ms. White, please.
Thank you. I just want to add on to what Tracy was saying about the pickups and possibly having scanning there at the drop boxes. I'm absolutely opposed to that, because you might not have observers following to see what's happening at that drop box location. So that is decreasing transparency. I don't see how it would help, really. And then there have not been hundreds of cases of election fraud that have been completed resulting in felonies for people who have committed election fraud. I think one case took like 4 years to get through and was only recently determined. So all of the consequences and the many times you've mentioned that it's a crime and a felony, those are kind of empty threats, empty penalties, because the convictions just aren't happening. And we know there have been hundreds, if not thousands, of actual felonies committed with the fraud throughout our state. So that's it. Thanks.
Yes, ma'am. Thank you for your comments. At this time, is there anybody else interested in making public comment relating to proposed regulation R093-21P? Mr. Mann, please.
Hi, Mark. Appreciate again all your hard work. Quick question. In this section, it states establish certain requirements relating to security and accessibility of ballot drop boxes. So in this section, does it address the allocation of drop boxes, their location, how they're distributed, or would that be state statute, or would that be at county or city level?
Thank you for the question, sir. So there's a couple locations to talk about the requirements. Primarily, I'm going to direct you towards Assembly Bill 321. The text of which, the link rather, to the text, I will put into the chat so that you can review those requirements there. That is also something that there's a number of discussions that are ongoing about best practices and the requirements, with the bottom line being that a lot of the county clerks and registrars have identified that there's likely going to be changes in what the allocations look like, depending on, first of all, in the chat now, Assembly Bill 321, there's the text of it as enrolled. A lot of discussion about, depending on what happens in 2022, if there are jumps in the number of personnel who use the mail-in ballots and maybe even use them and drop them off at ballot drop boxes. We're going to closely track not only the number that are dropped in drop boxes, but also their specific location. The idea being so that we can identify those hot spots, so to speak, around the counties where drop boxes are used more than others, perhaps, so that going forward, we can either consider increasing the size of the drop box, increasing the frequency that they are picked up by the ballot retrieval teams, or again, if it's the inverse, if less people are using them, then maybe reducing the number of drop boxes if necessary, based on if we find one that didn't have a single ballot put into it because the one a half block over or something was more frequently used. But again, the allocation across the counties is something that the clerks are keenly aware of, and making sure that they are even and equitable in those locations to meet the needs of their constituents. So if there's a specific location or concern, I recommend bringing that up with your clerk or registrar, highlighting the issue and the location and having that discussion with them. But thank you for your comments.
Excuse me, Mark. I just have a quick question, and I'm sorry if it's been answered already, but this is
Would you mind saying your name? Oh, sorry.
So, Darla Lee, for the record, yes. I'm curious how many drop boxes were used in Washoe County. Do you have any idea as compared to how many drop boxes were, used or put out by the other counties?
One moment, man. Let me see if I can pull that data up right now. If not, then I'll get it to you for sure. 1 second though, please. So I have the information in front of me. Unfortunately, I have it in 17 different files reflecting 17 different counties, which isn't ideal. What I'll be able to do though is I can tell you right now that in the 2020 election cycle, on election day, Washoe County had 29 polling locations on election day. And of those 29 polling locations, There were 16 that had drop-off early election day drop-off locations. Looking at Washoe County for early voting. Early voting polling locations in Washoe County, there were 15. And all 15 had a ballot drop box location inside them. But again, I can provide an analysis of that compared to the other counties separately.
Okay. Yeah, no, that's fine. That answers my question. Thank you.
Yes, ma'am. Miss Reyes, Mr. Reyes.
That's me.
Oh,
Hi.
please say your name for the record.
Yeah,
Thank you.
it's Debbie Silva, and I'm from Minden in Douglas County. And I just wanted to speak in favor of efforts in the wording to expand drop boxes. And I believe that we need to make voting as easy as possible for the majority of people. Currently, we do not have enough people voting in our elections. So especially I want to support those who spoke earlier about drop boxes on the Indian reservations. I again am in favor of that. One concern I have is ensuring that the drop boxes continue to look and be official. And because we did have problems in California where one party established unofficial fake drop boxes. So that's my comments.
Yes, ma'am. Thank you for your comments. I do appreciate that. Mr. Mann, do you have comments or no? Okay. At this time, is there anybody else interested in making public comment regarding proposed regulation R 093-21P? Seeing none, then I'll close the public comment on R 09 proposed regulation R 093-21P and open the workshop on proposed regulation R 094-21P. If you are following along, we are on page 97, Existing law requires the county and city clerks to mail each active registered voter and each person who registers to vote or updates his or her voter registration information not later than 14 days before an election, a mail ballot for all elections. Existing law also, 1, establishes certain procedures for processing and counting mail ballots received by a county or city clerk, and 2, authorizes a county or city clerk to process and count mail ballots by computer or other electronic means. Sections 2 and 5 of this regulation require, beginning on the first day of the period for early voting, each county and city clerk to 1, count all return envelopes returned by mail in person at the clerk's office or deposited in a ballot box, 2, batch the return envelopes, and 3, record the total number of return envelopes received. Sections 2 and 5 further require each county and city clerk to forward any return envelope received for a different county or city to the county or city clerk of the correct county or city. Sections 3 and 6 of this regulation require the county or city clerk to 1, perform periodic audits of employees in the clerk's office whose regular duties involve checking signatures on mail ballots, and 2, if the county or city clerk uses an electronic device to sort mail ballots or capture digital image of a voter's signature, to test the electronic device before it is so used to ensure the electronic device is able to properly sort mail ballots or clearly or accurately capture the digital image of a signature on a mail ballot as applicable. Section, let's see here. At this time, if there's any proposed public comment, any public comment on proposed regulation R 094-21, please go ahead and indicate so in the Zoom now. I have been reminded that I should be kind of a little bit more stringent on not having folks kind of bounce back and forth. So please, if you do have public comment, I will set the timer, keep you to a couple minutes. I've been generous with the 2 minutes so far, but please, again, if you have public comment regarding proposed regulation R 094-21, please let me know and I will give you your chance to speak. Ms. White, please.
Thank you. Section 3.1, where you talk about the audit. No, the electronic device for the signature. Is there a risk limiting audit for that? And can a percentage here be stipulated, just like in the other risk limiting audit? And then 3.2 and also in section 6.2, what is the actual audit process on the employee who is checking signatures? I mean, how is the county clerk going to know what an audit of an employee looks like if you don't stipulate it in the regulations? And 3B, in Clark County last year, we saw huge problems with the signature verification equipment, and it was basically not used. It was set to 0, so it accepted all signatures. Not true? Okay, maybe you can elucidate. And so is there a base performance level for this electronic signature checking? Thank you.
Yes, ma'am. First, just to be clear, first, appreciate your comments. There's a number of things that we're taking into consideration, specifically relating to Clark County in the 2020 general, though. The Agilis machine rejected 70% of the ballots that went into it and said that they had to go to human verification by their bipartisan signature verification team in Clark County. So they did not allow 0%. They didn't just accept everything.
Okay, so it rejected 70% of them?
Yes, ma'am. Well, it said that they could not be confirmed by the machine. It was not close enough or accurate enough, given the algorithms the machine uses to look at signatures. That again, Agilis, owned by Runbeck, which is the company that does banking signature verifications. And so again, when in doubt, the machine spits it out and says humans need to look at this. And if there's any question beyond that, then it goes to signature curing.
Okay, so as I understand it, though, previous to that year, the kick out for signature was much less than 70%. So something changed. And if you have a piece of equipment that's performing at that level, shouldn't it be replaced? That would be a lousy piece of equipment. So how are we going to fix that problem? What in the regulations is going to address that issue of equipment that has a failure rate of 70%?
It doesn't have a failure rate. That's exactly how it's designed to function, to make sure that it doesn't allow every ballot to go through and instead is only verifying those that need to. So yes, ma'am, again, that it exceeds a little bit of what we're discussing here in regards to the 2020 election cycle. Please keep in mind too, that machine was only used in 2020 by Clark County, first in the primary, then in the general. So there's a number of ongoing things we're looking at as it relates to signature verification. But yes, ma'am, I'll certainly take that into consideration. Mr. Mann, do you have comments, please?
No, sir. Sorry.
Okay. Thank you. Is there any other public comment relating to proposed regulation R094-21P? And if you do come across something later, again, the adoption hearing is not until the 22nd. So please, absolutely put it into writing and send us an email and we'll read and consider that as well. Mr. Moore, please.
Did I understand correctly that every registered voter receives a mail-in ballot?
Every active registered voter, yes, sir, will receive a mail-in ballot pursuant to Assembly Bill 321.
And if that is linked, like that in the database, it's linked who received what mail-in ballot, if it's used or not used?
Yes, sir.
Thank you.
Yes, sir. So if there are no further public comments on proposed regulation R094-21P, I will close public comment. Oh, Mr. Bentham.
My question is, you said the active voters were going to get mail-in ballots. What about the inactive? They can still vote in person, right?
Yes, sir. They do not get a ballot mailed to them, but an inactive voter, which again does not mean that they haven't participated, but it simply means that the election officials have identified that their address is not current. That individual can go to the clerk's office, update their registration and become active and then still vote and participate in the process.
Okay, thank you.
Yes, sir. If there's no further public comment on proposed regulation R094-21P, I will close public comment and we will begin the workshop on proposed regulation R095-21P. For those of you that are following, we are now on page 103. Existing law 1 requires a county and city clerk to establish procedures for the processing and counting of mail ballots. And 2 authorizes the county and city clerk to review the signature of a voter on a mail ballot manually or by electronic means. Sections 2 and 5 of this regulation provide that an electronic device was used in an election to verify signatures on mail ballots may only be connected to a computer network for maintenance and support, and such a computer network must be closed, secure, and behind a firewall. Sections 2 and 5 further require that the county and city clerk keep maintenance logs documenting certain information regarding maintenance performed on the electronic device. Existing law provides that if a county or city clerk uses an electronic device to verify signatures on mail ballots, the clerk must 1, conduct a test of the accuracy of every electronic device before the election, 2, perform daily audits of the electronic device during the processing of ballots for the election, and 3, prepare an audit report. Sections 3 and 6 of this regulation set forth requirements for the daily audit of an electronic device used to verify signatures on mail ballots. Sections 3 and 6 provide that if during the daily audit, a manual review of signatures verified by the electronic device results in a signature being rejected by the auditors that was verified by the electronic device fails the audit, and the county or city clerk must stop using the device immediately and notify the Secretary of State. At this time, if there's any question, proposed public comment regarding proposed regulation R095-21, please go ahead and indicate so in Zoom now. Ms. White, please.
Section 2, where the electronic device, when it is connected for maintenance or support, how can we, the public, have transparency to know that the device is on a secure closed network? How can we know that? Where is the observation process? And it would need to
I'll clarify in regards
daily.
to
It would need to be done daily, right? Or
Yes,
even
ma'am.
hourly. So is that stipulated any place in here where observers can make sure that it's behind a firewall? How are we supposed to be able to test that? That's the question.
I see. Yes, ma'am. I'll take that note down and see if we can't consider a way to amend the text. But thank you for the comments. Mr. Moore, please.
Yes, thank you, Mark. What is exactly meant by connected? And the context of my question is I seem to remember there was a play on words when Dominion or others said, no, our machines are never connected to the internet, and they weren't wired to the internet, but there were other means, wireless means, Bluetooth or what have you, where there was connection. So we are using the word connected, and I need to understand what that means.
So that's a good point as it relates to this regulation. I'll take a recommendation down to maybe expand upon and clarify what does it mean connected, and clarify that it's not just a hard line, but also again, not connected via Bluetooth, wireless, or any other wireless form of electronic communication.
Yes, and in that a little nuance, I'm not a tech savvy at all, but from what I understand, even we should have in there that the equipment should not even have the ability to be connected wireless, because I think that was another nuance where if you're saying it's not connected, why do you have this component inside? Thank you, Mark.
Yes, sir. Thank you for your comments. Mr. Benton, do you have a comment?
Yes, I do. My comment is, if your ballot is rejected because of your signature, and then it goes to like a group to evaluate it because the machine kicked it out, that group might decide it's not valid signature, but it might actually be, because well, like my signature, I'm sure changes. So I guess I would either like to mandate that, I know this would be difficult, that the voter would have a chance to at least know that there was a question about their signature and evaluate it. Or I'd be willing to put my thumbprint on my ballot when I mailed in, so that that would, even though my signature changed, my thumbprint wouldn't. That's, and I want to thank you, Mark, for everything you're doing. It's pretty amazing. Thank you.
Sir, I appreciate that, and I will certainly pass it on to the team. Again, I do nothing alone, from the secretary's direction down through the elections division and the county clerks and their staff. This is definitely a full-time, full team effort, but I appreciate that. We'll pass it on. I think you'll be happy to know that there is an entire section talking about signature curing, the process, just like you described. If there's any question about the signature that's on your voter registration and what's on the ballot, then really there is no question, and your clerk is going to reach out to you to ask you, is this your ballot? Did you sign this? Can you confirm that this is you? Because you're right, the idea of discounting a ballot without having the voter provide an opportunity to say, no, that is me. That's something that the clerks are very keenly aware of and want to make sure that we clarify with the voter. And in fact, if there's a question, if we see your ballot and say, that doesn't look like Mr. Bantham's signature over any of the documents you've ever provided to your clerk, any of the voter registration documents over the years, they have the ability to compare those as well and kind of look to see, well, the A is kind of changed, or maybe this hasn't. But again, if there's a question, they're just going to reach out to you. And if it's, well, this doesn't even look remotely like it, and we try to contact you and you don't answer, or you're out of town, or you didn't vote, well, this ballot does not get cast. It does not get counted, and it gets set aside. And there were about 2,000 or so, a little bit more than 2,000 that had that happen. Ballots that were cast by mail, signatures didn't match, voter didn't respond to the curing process, and those ballots weren't counted.
Okay, thank you.
But there's certainly an effort to reach out to them, postcards, mail, or email, texts, calls, all sorts of things. Yes, sir. Thank you, though. Ms. Thomas, please.
Just thank you again for establishing documentation to standardize best practices for all counties going forward, and making this process transparent in that process. I also wanted to ask if there has been any discussion in providing the option to provide a thumbprint versus a signature, if that voter prefers that as their preferred method of identification. Is there any discussion on starting that process and not making it a requirement, because I know it validates some things, but some voters would prefer to have a thumbprint, and is that should be an option that could be available in the future?
Thank you for your comments, Ms. Thomas. Certainly something we're taking into consideration. There's a lot of ongoing discussion about signatures, what could be better, trying to think 5, 10, 15 years in the future. What developing technologies are there that they could be used. Certainly going to be careful in those discussions. Of course, we're not, as the state, a lot of these are defined by statute. So it's not something that the Secretary of State, either Secretary Sagaski or any, the future secretary after the election could do unilaterally. But I will tell you, in the election space, there was a lot of discussion about, ways that we can ensure security of ballots while concurrently ensuring that the security of your thumbprint, right? Like you wouldn't want, like biometric data to get leaked. That also would be terrible. It's bad enough when the Office of Personnel Management leaked my social security number about 15 times. So I wouldn't want to extend that to anybody or have any additional information leaked as well. But yes, ma'am, lots of discussions going on about that and thinking about the future. Mr. Moore, please.
Yes, I have a vague memory of, I think it was Arizona, that had issues where they tried to cure signature under the pretext of curing signatures. There was signature abuse, but I don't remember the details at all. Do you know, or is your office aware of any kind of fraudulent acts when the clerk's office has a difficult to match signature and it turned out to be some sort of fraudulent curing process?
Whenever we've again gone through the curing process, and again, that's still a relatively new process here in the state. Again, there's any anomaly that comes up, any question about the indication of the individual who responds. Again, the first step is to confirm it, so that if we reached out and said, Mr. Moore, we got a ballot from you, we have a question about the signature, that we're not going to just accept that if we call, the last recorded phone number, for example, and someone says, hello, and we said, is this your ballot? Like there's a validation process that goes into it. If there's any questions about that validation process, then we investigate it. Absolutely. But again, have we found any indications here of a fraudulent signature? Not yet, but we will certainly keep looking.
Okay. Okay, we'll leave it at that. Thank you.
Yes, sir. At this time, is there any other, Mr. Mann, do you have a question or a comment rather?
No, Mark, thank you.
Yes, sir. At this time, is there anybody else interested in making public comment regarding proposed regulation R095-21? If no, then if not, then I will close public comment on proposed regulation R095-21, and we will move on to the workshop for proposed regulation R096-21. I'm now on page 109. Existing law authorizes the county or city clerk to create such boards and appoint officers as the clerk deems necessary for the expeditious processing of ballots. Sections 2 and 5 of this regulation authorize the county clerk and city clerk to create vote adjudication boards for the purpose of resolving the intent of a voter in casting a ballot. The voter's selection in relation to a particular race or ballot question cannot be determined using a mechanical device or other electronic means. Existing law authorizes the county clerk and city clerk to create ballot duplication boards whose duties include receiving damaged ballots and preparing exact copies of damaged ballots so that the duplicated ballot may later be counted. Sections 3 and 6 of this regulation, 1, set forth certain procedures for a ballot duplication board when duplicating a ballot, and 2, require each county and city clerk to submit for the approval of the Secretary of State a procedure for duplicating ballots before it is used in the county or city as applicable. At this time, if anyone is interested in providing public comment regarding proposed regulation R096-21, please go ahead and indicate so in Zoom now. Ms. White, please.
Thank you. Section 2.1, and I guess it's a few other places, to the if practicable language needs to be removed and changed to must. I mean, if you want transparency by all parties, that needs to be there. They shouldn't be completing the action if they can't have bipartisan observers. 3.1, it says that the duplication process needs to be delineated and submitted to the Secretary of State so she could require their plan for how they are going to duplicate ballots. So that means the Secretary of State must have a list of behaviors that are found in any good practice. Where can I find that information for her to approve each county's duplication process? And shouldn't it be delineated in these regulations if the desire is to standardize the practice among the counties? Thank you.
Yes, ma'am. Again, that will be in the elections procedure manual that's under development and approaching the point where we're going to be able to publish it. Again, will be a public document. It'll also be a living document so that as we go forward, as new best practices emerge, we can incorporate and keep that timely and relevant. But yes, ma'am, that will be published as well. And you will see the link in the 2022 election page that I sent earlier. I will absolutely notice that there as well for everyone's review.
So is the elections procedures manual, is there an existing one or is this a new document?
It is a new document. Other states have it as a required by statute. We have a number of guides, initiative and referendum guides, recall guides, candidate guides. We're combining a lot of those documents and making we're adding to it considerably with things like voter intent, duplication, best practices, and other things. It's about 500 pages, I think, at this point, as we continue to work on it and refine it. And then the goal is, again, there's further discussion about codifying that through the regulatory process later on, or possibly even considering maybe a BDR to make it a statutory requirement. But again, a lot of those discussions are ongoing as well. But again, in the interests of getting it done right, this first version will be out here shortly for the clerk's review as well as public consumption and discussion.
I know that Arizona has one. Would
Yep.
you by any chance be using that as a template?
There's a number that we looked at, not a template per se, but we certainly reviewed.
Starting point.
Yep, exactly. Like review the table of contents, thought, well, what if there's a bunch of things that are legal there that aren't here and vice versa. But yes, ma'am, something.
And will there be workshops for approving that procedures manual?
When it gets to the point where if it is ultimately governed by regulation or statute, then absolutely those would be certainly open to public comment and revisions and suggestions. But that is, because it doesn't carry the weight of law yet. This is a best practices manual for standardization rooted in these regulations. It doesn't necessarily follow that same process. It's, again, definitely open to public comment and feedback on it, though. Absolutely.
I know that the clerks, et cetera, are going to have lots of suggestions for that procedures manual. Is there going to be an opportunity for public input?
Every day when you read it, again, like I said, it's about 500, maybe 600 pages by the time it's done. As you identify suggestions, please let us know.
Okay, so you're saying in that link that you put in here that shows updates.
Yep.
It has that section and it's called Elections Procedures Manual.
It's not posted yet because we're not done finalizing the review of it. But when it is and we publicly post it, it will have a link on that page. Yes.
And it will be in draft form waiting for public input.
It probably won't be in draft form, but it will always be available for public input. Again, because it's not confined by the same regulatory process yet. It won't carry the weight of law. It's not a regulation yet, as it may be.
Okay, thank you.
Yes, ma'am. Ms. Thomas, please.
I know I'm sounding like a broken record, but I would like to suggest striking if practicable. I mean, I think it should be done. It should be a requirement that members must be of different political parties. So if you can't strike if practicable, maybe some verbiage could be added that if it is not done, that there be written, justification for why it is not done by the clerk. Thank you.
Yes, ma'am. We'll take that into consideration. Thank you.
May I speak again?
Yes, ma'am.
Is there the names of the people who are on the duplicating, who are doing the duplicating, are those available for the public to know?
So those are, again, county employees, but yes, ma'am, those are, I don't know if I believe every county has the ability to provide those.
I mean, it would just be nice to know, day 7 at the daytime shift, these employees were assigned to that duty so that we would know who was doing the duplicating at that point in time. So does the clerk or the registrar keep a record of who is doing what job each day?
Oh, I'm certain they do. Yes, ma'am.
Okay, thank you.
Mark Darla Lee, is it all right for my husband to make a comment?
Of course. Yes, ma'am. Would he be able to state his name for the record, please?
Yeah, George Lee. And I'd like to ask if it's in the manual and current practices that the copy of the ballot remain attached to the original and that they are stored for audit. That's what I really wanted to find out. Is that currently practice? Is that going to stay a practice?
Yes, sir. I understand the question. I'll confirm with the counties just to make sure that there are no discrepancies across the 17 of them. But I do know that the original as well as the duplicated ballot are retained for 22 months for audit purposes. And I would I'll confirm. I believe I remember hearing, but I don't want to misspeak, that they are kept together specifically to address that this was a duplicated ballot of the other one. And
Right,
not just,
I was just trying to make sure that it wasn't going to be an electronic copy and then therefore to be lost from the original.
yes, sir.
Yeah, that's it. We'd like to see that happen.
Yes, sir. Thank you for your comments. At this time, is there any other public comment relating to proposed regulation R096-21? If not, then I will close public comment on proposed regulation R096-21 and open the workshop on proposed regulation R097-21. I am looking at page 115. Existing law requires each county and city clerk to 1, prepare and distribute sample ballots for an election, and 2, ensure that a copy of each sample ballot is posted at each polling place. Existing regulations require that the county or city clerk prepare a sufficient number of explanations to the questions on the ballot so that in relevant part, he or she can post at least 2 copies of the explanations in each precinct. Sections 3 and 10 of this regulation provide instead that the county or city clerk prepare a sufficient number of explanations of the questions on the ballot so that in relevant part, he or she can post at least 2 copies of the explanations in each polling place. Existing law authorizes 1, a county or city clerk to establish 1 or more polling places in that county or city as applicable, where any person entitled to vote in the county or city by personal appearance may do so on the day of the primary election, primary city election, general election, or general city election. And 2, any person entitled to vote in the county or city is applicable by personal appearance to do so at any such polling place. A polling place where any person entitled to vote in the county or city by personal appearance may do so is commonly known as a vote center. Existing regulations require that the county or city clerk, as applicable, prepare certain election supplies and equipment for each precinct, including at least 3 copies of each sample ballot which pertains to the election. Sections 4 and 13 of this regulation instead require that the county or city clerk, as applicable, prepare certain election supplies and equipment for each polling place. If the polling place is a vote center, the election supplies and equipment must include a means to print each sample ballot which pertains to the election upon request. Sections 2 and 8 of this regulation define the term vote center. Existing law requires each voting system to be used by a county or city to provide voting materials in English and certain other language as required by federal law or is authorized by the clerk. Existing regulations provide that if a procedure for bilingual voting is used in a county or city, each county and city must prepare for each polling place certain required notices in the approved foreign language. Sections 5 and 12 of this regulation provide instead that if a procedure for multilingual voting is used in the county or city, certain notices must be provided in the appropriate foreign languages. Existing regulations provide that if a difference exists between the number of persons voting and the number of ballots cast in an election, the difference must be reported in writing to the county or city clerk as applicable, together with any known reason for their difference. Sections 6 and 14 of this regulation provide instead that after the close of polls on the day of the election board must determine the total number of 1, persons who applied to vote and voted in person at the polling place, and 2, ballots cast at the polling place. If a difference exists between those 2 numbers, the difference must be reported to the county or city clerk as applicable, together with any known reasons for the difference. Sections 1 and 9 of this regulation provide a similar process for each day of voting during the period for early voting. Existing law requires the city clerk to appoint and notify registered voters to act as election board officers for the various polling places and precincts in the city. Existing regulations provide that if an election board or of more than 3 members is required to accommodate the number of registered voters in any precinct, the city clerk may appoint as many additional members as he or she believes are necessary or desirable. Section 11 of this regulation provides instead that if an election board of more than 3 members is required to accommodate the number of registered voters who may vote at a polling place or in any precinct, the city clerk may appoint as many additional members as he or she believes are necessary or desirable. Existing regulations require that there be an adequate supply as determined by the city clerk of voting booths for each precinct. Section 15 of this regulation requires instead that there be an adequate supply of voting booths as determined by the city clerk for each polling place. Existing regulations provide that for a city election, if any polling place is closed early because all the voters registered in the precinct have voted, the election board is required to notify the members of the counting board of the closing immediately. Section 16 of this regulation provides instead that any polling place that is not a vote center is closed early because all the voters registered in the precinct have voted. The election board is required to notify the members of the counting board of the closing immediately. At this time, if you're interested in making public comment relating to proposed regulation R097-21, please go ahead and indicate in the Zoom now. Ms. Thomas, please.
Thank you. I just wanted to thank you once again for documenting established best practices that have been being conducted at our polling locations and to actually establish it to be congruent across all counties. Thank you.
Yes, ma'am. Thank you for your comments. Ms. White, please.
Section 9, excuse me, section 9(1)B, reporting the difference between the ballots and the number of persons. Can you add in there daily? Because if it shows up that there is a large no reconcile each day, it would indicate that she needs better staffing. So would that be able to be put in there?
Yes, ma'am. I will clarify and we'll take that into consideration for sure. Though I believe it is already daily. We'll certainly discuss and consider that for an amendment. At this time, is there anyone else interested in making public comment on proposed regulation R097-21? Hearing none, I will close public comment on proposed regulation R097-21 and open the workshop on proposed regulation R098-21. I'm looking at page 131 now, 131 for proposed regulation R098-21. Existing regulations authorize any person to observe the conduct of voting at a polling place in an area designated by the chair of the election board. The designated area must allow for meaningful observation, but must not be located in an area that would allow an observer to infringe on the privacy and confidentiality of the ballot of the voter. This regulation 1 clarifies the term polling place to include a polling place for early voting and vote center, and 2 defines the term meaningful observation. This regulation also authorizes the county or city clerk to limit the number of persons observing the conduct of voting at a polling place for reasons of public safety or to preserve voter privacy or maintain order. If you're interested in providing public comment regarding the proposed regulation R098-21, please go ahead and indicate so now. Ms. Martinez, please.
Yes, thank you, Senator. For the record, Cindy Martinez, Vice Chair of the Washoe County Republican Party. Is there, I don't see it in this proposed regulation. Is it anywhere else that there's some requirements that the person must be a registered voter in the state of Nevada? Because we had a large number of people who were bussed in from California to quote observe and I would posit to influence our election. Is there any means of clarification on
that? No, ma'am. So when it comes to the observation, again, there are very clear guidelines that again, anyone, it's not just Nevada voters, it's not just Nevadans, that it can be observers. So no, ma'am, that there is no requirement identified in this regulation in that regard.
Okay, so one other point then, because as a poll watcher, we were specifically, we were assigned by shifts, and it was a bipartisan assignment. So if that's what we're doing voluntarily, obviously, because we believe in transparency and fairness, here you have a process on who can observe. So am I misunderstanding then? You're saying that there's no specificity about who can observe? Because my understanding is that the observers we were confined to a point of observation. But if you wanted to watch the election, you can't really hang out in a polling place. What am I missing here?
Ma'am, so I think the definition that I just put into the chat of NRS 293-274, that's the statute that identifies that members of the general public are allowed to observe conduct of voting at a polling place. And describes it. So that's the statute that we have to operate under as it relates to the general public.
Okay, so if we were told, if folks were told, once you vote, you got to move on, then that's incorrectly interpreted and applied there at the local. Is that a misunderstanding?
If someone was told that they voted and then were told they have to leave, is
Yeah,
that?
yeah. I mean, most people want to come in and vote and get the business done and move on down the road, but
Right.
My understanding is that they didn't really permit just the general public to hang around and look and see what was going on. Is that, am I missing a point here?
I will have to ask some questions about that. I believe if you come in and you're voting in person and you cast your ballot, and I'll clarify this, but I think if you identify to the clerk registrar that you're interested in observing, it's not that you would stand in that same spot necessarily or there amongst the voting machines and possibly risk negating somebody else's privacy. But then it's almost like you leave and then kind of come around to the observation location, if that makes sense.
Yeah, it does. Yeah, okay, thanks.
Yes, ma'am. Ms. White, please.
Thank you. The term meaningful observation was defined, and is this same definition going to be used elsewhere in other regulations is this definition going to apply any place else in the regulations where this is defined? It's defined right here. If meaningful observation is used anywhere else in regulations, is it going to refer back to this definition?
So, ma'am, specifically, it says right before that as used in this section.
Okay.
So that limits it to simply this regulation.
Okay, and then just where it says means a person may observe the identification of voters. So identification, is that just visual identification, or may I see something on the poll book, the observers, that identifies? Identification, there's various ways of identifying something.
I think I understand your recommendation to maybe expand upon and clarify what exactly is being referred to here. Is that accurate?
Yeah. I mean, if I saw the poll book, I would be able to identify something about that individual, or if I looked at them, I'd be able to identify something about what is it talking about, really? Thank you.
Yes, ma'am. Mr. Moore, please.
I'm always amazed with some of the information I'm learning here. So I'm very uncomfortable with out-of-state observers because it's generally not people that are so concerned about integrity of our Nevada voting system. It's usually, if somebody's from out of state, it's an organized attempt. Why would an organized group of people want to go ahead and become observers in Nevada? So my question is, are you able to make any kind of notes or messaging to the legislating process that you can already start the ball rolling, that we want to address that situation in the legislature side? Because what I'm afraid of is that we get informed way too late, or at least the general public is not aware of a particular problem that needs addressing. It might even have been an oversight on the legislation side that they didn't think about it. It might have been intentional, but we need to go ahead and at least follow this up somehow. So if it was a corporation, for example, and it was in another division of a corporation, we would at least have a way to go ahead and say, hey, we heard this. Is this something that you can go ahead and look at? And I mean officially, not just a telephone call, say, hey, this came up.
Yes, sir. So there's a number of ways that you could address that. Again, either by if you provide something to NB-elect and direct it to the secretary, she will get the note, and there's a means there. You can also, again, talk to your legislators about it and try to see if that's something that's interesting. I seem to recall, though, that there were numbers of organizations from across the country and frankly, across the different parties that sent observers to Nevada to observe our elections for a number of reasons. Frankly, I couldn't get into the why necessarily, or I wouldn't want to speak for them. But I do know that was a much more common practice than maybe a lot of folks realized. We have international observers too. We actually send people, from the United States to other countries to observe their elections, and in return, have a number of individuals coming from other countries to see our elections as well. But
I might be mixing up terms then. Maybe the terms are being mixed up. My understanding is we have bilateral or bi-party controls to make sure that any human interpretation of what a vote is for candidate A, B, C.
Oh, yes, sir. So in regards to the poll workers, yes, sir. That's required to be, registered voters. But I'm talking, this is purely like the general public, high school kids, folks from Utah.
Okay. No, so then are we still using the term observers in both cases?
No, sir. The very distinct terminology.
Okay,
Yes,
so
sir.
poll watcher and observer, those are the two.
A poll worker or election board officer is the statutory term that we're trying to use more now,
Okay.
which is a poll worker. Those are, again, typically hired at the county level, so they become temporary county employees. Yes, sir. In that
Okay.
regard. These are just, again, I'm in high school. I'm in.
No, that's fine.
Yes, sir.
I apologize for my ignorance, but now I understand.
Yes, sir. I'm here to help, sir. Ms. Martinez, please. Ms. White, do you have a comment, please?
Yes, thank you. I understand that we want to make our election processes open to the public, and that could be in-state or out-of-state people. But as our state elections, state residents should be able to be guaranteed a seat at the table as far as being an observer. So is there any way to include language that says wherever the observation process is happening, that it must include at least 3 Nevada state residents? I mean, imagine, if all of New York came to observe our elections and the registrar of voter or county clerk said, no, we can only have 4 people in here and all 4 seats go to out-of-state observers. That's disenfranchising Nevada state voters from observing. So if you could include that language, I think that would be helpful. Thank you.
Yes, ma'am. I'll take that into consideration. Thank you. At this time, are there any other proposed?
Yeah, Darla Lee for the record.
Yes,
Yeah,
ma'am.
I would like to echo Ms. White's recommendation, because as a poll observer at the last election, I know that I was seated next to someone, lawyers from California on several occasions at the polling. And these lawyers and observers would exit the polling place if someone came up to the to vote and had a problem, whatever, and were told to, go to somebody else for. That person would immediately run out and stop the person, usually within the 100-foot limit, as I observed, and would speak with that person and give them their card to contact the Democrat, people to help with their problem, quote unquote. So this I reported to the manager, and this happened on several occasions. So I would say that if there are so many people interested from California, especially lawyers, then we need to have some stipulation that Nevada residents and voters should have the priority in that observation. Thank you.
Thank you, ma'am, for your comments. We'll certainly take into consideration. At this, Mr. Moore.
Sorry, but now that just opened up a different perspective again for me. What is an observer? What Ms. Lee just said is frightening. You gave the impression, and I don't think you did it for any nefarious reason, but you gave the impression, at least to me, that, okay, well, just like a open heart surgery, you have that atrium where you have people observing. I'm thinking, okay, that's great, or 12-year-olds learn how our system works. That would be wonderful. But now I'm hearing where we've got, third-party influences coming in under the guise of observing and using that opportunity to persuade people to do one thing or the other. That's not observing.
It's not, you're right, sir. That's actually electioneering. That's against the law. And if you see anyone doing that, tell the clerk or registrar or any of the supervisors, and they will address it on the spot. Absolutely agree.
But couldn't we put something in there that defines what observing is in the regulation? That by observing, it is clear that these people, that any observer is, even if it's redundant, but forbidden to do X, Y, and Z?
Yes, sir. I'll certainly take it into consideration and see what we can, in regards to modifying the text potentially before the adoption hearing.
Thank you, sir.
Thank you for your comments. Mr. Smith, good morning.
Morning. Hi, everyone. My name is Jeff Smith. I am with Nevada Democratic Victory. We're going to be overseeing some of these poll observers. I just wanted to clarify the 100-foot rule. We instruct all of our people, you don't talk to voters inside the 100 feet. Like if you see that, please, by all means, report them because they're breaking our rules too. So, we try to cover that a lot. As far as the, kind of Nevada versus California, my thing is, as long as, yes, that's right. That's my name, Jeff Smith, Nevada Democratic Victory. You can look that up. Yeah, so, I want to be clear about this. We are not around to talk to people inside the, kind of thing, right? We just want to make sure that if people are having problems, like if they're, inside and they're trying to get registered or whatever, and we only want like valid voters. Like we're not trying to like get Californians to vote or whatever else. But we want to make sure that everybody's rights are protected. So if they run into some problem on the inside, we will follow them outside of the 100 feet and make sure that, talk to them like, are you eligible to vote? If so, did you show whatever you needed to do? Did you say whatever you needed to say? Do you need to go home and get something? Do you need to bring that back? We do that. That is what we do. So, that shouldn't be a problem for anyone. I don't see how that really, puts the election at risk or anything like that. So I just wanted to say that.
Thank you, Mr. Smith. Appreciate your comments. Mr. Moore.
Yeah, and I would like to
just to clarify again, I don't want to get into a back and
it's
forth.
It's not a debate. Yeah, I won't debate. I won't cross that
Thank
line.
you, sir.
But then again, I'm confused of what the role of an observer is. From my naive understanding, when you go into a polling place, there are polling officials. I think you mentioned the correct term for me, but there are officials there that have been either temporarily or have previously already been employees of the county, whose job it is to help people, whatever party affiliation they have, to help people make sure that they can exercise their constitutional right if they are legally able to vote. It is not the job of an observer. That's A. And B, I go back to my 100-foot rule, which you told me earlier, I have to go through the legislative side, but it just confirms my fear. What the heck is 100 feet? It's nothing. My house, I can go nearly 100 feet. So, I can say, hey, come over here, which seems like what this Mr. Smith was referring to, that's their role. It's not their role, as I understand it. It's not an observer's role. My question would be, can you clarify that? As in my previous request to make some clarifications, that should be included. The observer's role is not to help voters. That's not their role. Their role is to observe. Poll workers' job is to help the voters.
Thank you, Mr. Moore, for your comments. We'll certainly take them into consideration.
Thank you.
At this time, is there anyone else interested in making public comment relating to proposed regulation R98-21? If not, then I'll close.
Yes. This is George Lee.
Oh, sir.
Yeah. It's not meant to be, the observer section is not meant to be a launch pad for activist lawyers. And it appears that the regulation is written because we don't think we have enough lawyers in Nevada to cover the polling places. And so they have to be shipped in from all over the country. I know that our state is a bellwether, an important area for the vote, and that this needs to be clarified for the people who want to observe so that there's space for them to get in and observe. I know that there are limitations as to the size of the polling place because they're in public buildings and things, and they are not in massive storehouses or something. But this needs to be preserved for citizens who want to observe. Yeah, that's it. Thanks.
Thank you, Mr. Lee. Appreciate your comments. We'll take them into consideration. At this time, is there anybody else interested in making a public comment regarding proposed regulation R098-21? If not, then I'll close public comment on proposed regulation R098-21. At this point, again, this is the final public comment relating to items not already on the agenda. If you have any interest in providing public comment on an item not on the agenda, again, you'll have 2 minutes. Please go ahead and raise your hand now. Ms. White, please.
Can you please give me some assistance in locating the information about the total cost of the last election? I would like the final bill on what Nevada spent on the last election. I'd like to compare it to what we're going to spend this year when I get that information, and maybe to past years. So is there a particular direction or link you can give me for that?
Ma'am, we'll be able to provide that information through our public information officer. But yes, ma'am, we'll certainly be able to do that separately. Mr. Benton, please.
Oh, okay. Thank you. I just had a few questions. First of all, is there a record of the chat so that I could review like all the websites?
Yes, sir, there is. And in fact, because that's 2 questions in a row, I'm going to copy our public information officer's email into the chat for everyone's use. Please reach out to her and she'll be able to provide that.
Okay, thank you. And I definitely support the best practices for all counties. And I support provisional ballots being a different color so that they can help assist those people dealing with those. And earlier I was talking about verification of signatures, and I thought, well, maybe I'll do a thumbprint. But instead, I would like the opportunity to present my ID. If there could be a way to just say, well, this voter submits their ID to verify their signature and their picture and who they are. So I guess I would scratch the thumbprint and ask for the opportunities to use my ID. And thank you.
Yes, sir. Thank you for your comments. Ms. Lee, please.
This is George Lee. Outside of the regulations that have been discussed, I would like to see I would like to see the elections tightened up and they cut down on the number of days. I know that this is legislative, but cut down on the number of days in early voting and move people back to going to the polls on polling day. And because that seems to be the place where people can get the best shake. There's the least number of hands touching stuff. The signatures are verified at the polling place, and all of this stuff with using electronic machines to verify them could be done away with. It just seems foolish to even support a machine that has 70% out, kick out of errors, or 68% or whatever it is. That's just insane. If you had a car that only worked 30% of the time, I think you'd get it fixed. Anyway, that's it. Thank you.
Thank you, Mr. Lee. Ms. Lee, do you have comments as well, or while you have the mic? Nope.
Okay, say, Marilyn.
No, thank you.
Oh, yes, ma'am. Okay, Ms. Martinez, please.
By the way.
Yes, thank you, Mark. Again, for the record, Cindy Martinez, Vice Chair of the Washoe County Republican Party. Mark, again, thank you very much for your wide-ranging permission of discussing these points. I think all points from both sides of the aisle are being articulated and well worth considering. It's interesting. I pulled up I buy a hard copy calendar every year, and I looked at this one for 2022, which I bought in October of 21, and clearly marked on it for November 8th, it says Election Day. And of course, I come from a generation where we understood what the sanctity of one's election or responsibility to vote was. So I know that I work, as well as other people that I know, we work our schedules around making sure that we are informed and we show up for that. What I'm troubled by, not only by the legislation passed in the 81st legislature, but also these regulations, is that this is further erosion of our constitutional representation. It's further erosion of our basis of government as a constitutional representative republic. And it is enforcing and strengthening the autocratic Marxist application of government. This is unacceptable to freedom-loving Nevadans. Now, freedom is a responsibility, and I would entreat everybody that's on this call, regardless of political affiliation, is to work within your own counties to bring this electoral process back to where you have local control. What happens in Washoe County with 487,000 people might be markedly different than what's deployed in Eureka with a little over 600 people in that county. Regardless, the mechanism that you're describing with these regulations for oversight is problematic, because I think earlier in one of these conversations you indicated that there was that you don't have the staffing to implement this. So you're putting in regulations for you in the general sense, the SOS regulations, with no means of compliance, audit, enforcement, reporting. And even if I think one of these said 45 days of reporting, 45 days past the election, as we saw in 2020, is insufficient, and it's grossly irresponsible to secure the integrity of our elections. So I know that we're working here in Washoe County to bring that back to the local level. Election day should be election day with a justifiable application for absentee ballot. And there shouldn't be this universal mail-in ballot. I understand it's codified in statute, but we're going to work to turn that around. Thank you.
Thank you, Ms. Martinez. Mr. Beatles, please.
Thank you. Yeah, just a simple question, really. So, you guys know that I'm against this entire process. And how do we expect to have a free and fair election if, number one, we can't, of course, audit the source code of the machines? Number two, audit the physical ballots that have been cast. And then number three, we're not allowed to actually, you mentioned observe quite a bit, but we're not allowed to actually observe the actual vote, the actual counting of ballots, that entire process. We're told that we're not allowed to do that. So how can we trust this election at all if, number one, we can't audit the source code, we can't physically audit the ballots, and we can't be present when the ballots are actually counted? How do you expect us to have any faith in this election system, Mark?
Mr. Beatles, is that the end of your comment?
I'd love a response. How can we trust this election system if we can't be present for the ballots when they're counted, we can't audit the source code, and we can't audit the physical ballots? How can we trust this process? Question.
At the end of the day, sir, I am here to help support the execution and enforcement of these provisions. While the observation and some of these other things you talked about, I think are absolutely, they open opportunities for individuals to increase their trust. Is there room for improvement? Possibly. Are we operating underneath statutes that guide the actions? Absolutely. So from a purely, relating to your trust, I don't really have a way to answer or comment on that. All I can say is that, again, we're following the statutes as they're written, and there's a separate process outside of this workshop to address those statutes that you think maybe need to be modified or adjusted.
Interesting.
Mr. Moore, please.
Coming. Okay. Is it possible to ask, or is it even conceivable that the legislative side could participate by sending a staff member from each party, for instance, to these workshops? Are they already invited? Or the reason why I ask this, many of the comments that either I hear or I create myself seem to be too late, that we need to have the legislation change. And I would like to know if they could participate in this.
Sir, I appreciate your question. Many of them do know about these processes because they're publicly noticed. I won't speak for them, but I believe that, again, many of them wait for the discussions to occur. So that way the adoption hearings happen, and then that they're prepared and ready to review and discuss the regulations at the Legislative Commission. There are other legislators who have reached out to discuss these as well. So I do know that many of them are aware, but perhaps all. I won't speak to that. But I do believe that between now and the Legislative Commission, again, if you have concerns that you would like to voice, that's the window of time to do so.
Okay, and then public notice. I know it's up to the citizen to get involved, but if I look at the number of participants yesterday and today, compared to the number of registered voters, it's shocking to me. When I decided to join yesterday, I was imagining thousands, would be on here. But I only found out about it by chance, and the fault is mine. But it seems like I'm one of millions who are faulted for not knowing how this works, how to get involved, and so forth. But yet we see all kinds of advertising for all kinds of things on a daily basis. Why is there no campaign to inform the people how to get involved?
So there is, and we've done as best we can within not only the confines of the statutes, but within the confines of our budget to get the word out. If you or anybody you know has interest in these regulation type hearings or anything coming out of the Office of the Secretary of State, I did just put a link to our e-notifier in the chat. If you go on there, you're actually able to sign up, and you can identify if you want to be notified about everything from political action committees to the posting of an initiative petition or referendum, candidate filings, press releases and the like. So that's one way. We try to put it out on Twitter to the best of our ability. Again, so I encourage you to, if you haven't followed the NBSOS or NBElect Twitter pages, if that's something that you do, then those are options as well. But yes, sir, that's something too that we're considering ways to improve our process. Frankly, I also assumed that we would have thousands of people involved in these. And while I'm happy that we had the individuals we have over the roughly 20 hours or so that we've had the workshops and hearings, adoption hearings, again, the more is better, right? Like, we want to hear the voices of the people. That's extremely important to the secretary and myself and the rest of the elections division and the clerks and registrars. So yes, sir, that will continue to be an ongoing effort that we improve upon. But thank you for your participation and your comments.
Well, thank you. And I want to give you a special thanks. I can see it's not easy, especially those of us that hate this whole process to begin with, meaning the electronic process and machine process. But I thank you for your patience and professionalism. I also have to thank the participants, especially those that are so much more informed than I am, and people like me that are new to this or just citizens. It helps to have some of the very well outspoken people today to give me context. So thank you, everybody.
Yes, sir. Thank you. Ms. White, please.
Would you please remind me again where I can find the names of the legislators who are on the commission who will approve these regulations? And also a thank you for facilitating. I would not want to be in your shoes having to face all these questions. And to Barry, please reach out to washoegop.org if you want some contacts and how to get involved and get educated. Sounds like you're a new Nevadan. That's where I would start if I were you. Thank you, Mark.
Yes, ma'am. Thank you. And I just copied the link into the chat of the Legislative Commission's member page, which let me confirm. Yep. If you click on each name on there, it will go directly to their unique page that has contact information for them as well.
That's perfect. Thank you.
Glad to help. Ms. Trace. I'm sorry, I forgot your name, ma'am, from earlier.
I'm sorry, it's Debbie Silva.
Oh, sorry.
I enjoyed this process and I thought it was very interesting, but I say that I think some comments are not maybe appropriate for this forum. And I know that it's difficult for us to control people's comments, but this is not a forum for Republicans or Democrats to advocate for people to join their organizations. I want to say that I truly believe that the reason there are not a lot of people that participate in these processes is not just that they're uninformed, but that the majority of people in Nevada really are not opposed to the way in which our elections in Nevada are run and feel very comfortable and confident in this process. Of course, I think some improvements are very necessary, and I'm glad that you and the commission will be looking at them. But let's please be careful in our comments. I was really offended by comments about Marxism, which is really not anything to do with what we're doing now. Thank you.
Yes, ma'am. And I'll take the hit on that. There was some discussion before we had these about whether or not we allow chats. That there are certainly, if you've been involved in any workshops, regulations, or in other public meetings across the state, varying opinions on whether or not to even allow it in the first place. I chose to, in part because of the hope that it would allow someone who maybe whose microphone wasn't working to take part in the process. But then, of course, by doing so, it definitely opens me up to receiving, again, comments that maybe aren't necessarily related to the agenda. But I understand your comments, and we'll work to be more diligent about managing that in the future.
You did an excellent job. Thank you.
Thank you. Mr. Mann, just to clarify, do you have a comment?
Yes, briefly, for the record, Mark, it's Buddy Manuel. I'm sorry, my handle was shortened. I know you spoke earlier about the consolidation or putting together of a voter guide or a manual of some context, and it will be released soon. And that will be something, of course, that will be revised quite frequently. Can you put that, will that be resourced somewhere on your website, or where will we find that?
Yes, sir. Thank you for the question. I just put the link in the 2022 election information page. I keep citing that because I want as much as possible to not have information buried across multiple pages on our website. So I'm going to continue to put links to that and other valuable bits of information as they become available on that exact page. So that way it's a one-stop shop of where to go to find useful Nevada voter information for the 2022 election cycle, including the election procedure manual, to be clear.
Election procedure manual. Thank you again, Mark, for everything.
Yes, sir. Ms. Silva, do you have another comment?
I'm
Okay,
sorry. No, I do not have another comment. I'm sorry.
Okay. Yes, ma'am. At this time, then, if there's no more public comment relating to an item not on the agenda, seeing none. As a reminder, following the completion of the workshop today, the next step is the adoption hearing on February 22nd. I will put the notice in the chat one last time in case someone missed it. There's the notice for the adoption hearing on the 22nd. As well, following that meeting, we will have we'll be attending Legislative Commission on February 28th. That goes at 1 p.m. There's the chat there. Thank you, Ms. White, again for captioning my links. I do appreciate you having done that throughout the last few days. And I just put the link to the Legislative Commission in the chat as well. That's again February 28th at 1 p.m. But otherwise, again, from the secretary on down through the clerks and certainly myself, I do appreciate all of your attendance and involvement in this process. If you do have any questions, please let us know at nvelect@sos.nv.gov. Otherwise, I look forward to hearing from you all later on going forward. Thank you and have a good day.
Thank you, Mark.
Yes, ma'am.